Commissioner Schwartz.
Here.
Commissioner Peugeot.
Here.
Commissioner Lodge.
Here.
Commissioner Jordan.
Here.
Commissioner Higgins.
Here.
Vice Chair Campanella.
Here.
Chair Thompson.
Here. Mr. Busk, do we have any changes to the agenda?
No, Chair, we do not.
Any appeals?
No appeals to announce today.
Okay, next is review and approval of the minutes and resolutions from October 8th. Does anybody have any changes or a motion to approve?
Mr. Chair.
Commissioner Schwartz.
Thank you. Just a quick one. Mr. Rodriguez, on page 7, under my comments, this is the third bullet down, the sentence that reads, need to consider lines of sight. That should be spelled S-I-G-H-T instead of S-I-T-E. This is, so minutes of October 8th, page 7, under my section of comments towards the bottom. This is the third bullet point. And in the middle of that paragraph, the sentence that starts, need to consider lines of sight, and the S-I-T-E was meant as S-I-G-H-T. Got it? Great. Thank you so much.
Any other comments or changes?
Mr. Chair, just on both sets of these minutes, I'd just like to thank staff for going the extra mile and putting down comments as best they could, because both sets of minutes involved conversations more than just actions, and the conversations needed to be reviewed by others. I think they were important to us, and so I know it's more work, but I appreciate it.
Mr. Chair, I would concur with Commissioner Jordan's comments about the work done by them. They have it. The secretarial staff has a tough time sometimes figuring out what we really meant to say. So because of that, I made some changes, which I gave to Ms. Rodriguez ahead of time. And so with that and the corrections that Commissioner Schwartz made, I would move approval of the minutes as amended.
Okay, we have a motion and a second. Any further discussion? All in favor?
Aye.
Aye. Any opposed? All right, the minutes of October 8th are approved. Minutes of October 15th. Any comments or changes? Commissioner Campanella.
Thank you. On page 6, under my comments on the third bullet, fourth line down, beginning of a sentence at the end of that fourth line, he is open to looking, at short-term rentals. That should be corrected to home sharing rentals, which was the topic. Good. Thank you.
Okay, Commissioner Schwartz.
Yes, one small correction. Under my comments on page 6, Mr. Rodriguez, where it says Commissioner Schwartz stated that if we, and then the next word should be go. It says got, but just take out the T and we're fine there. We're good to go with that. Thank you. That's it.
Okay, Commissioner Lodge.
Thank you, Mr. Chair. Ms. Rodriguez, did I get to you some corrections on this, going back to the past tense on the actions in the first paragraph of the sentences, that we, instead of will hold, held? Oh, okay. I just wanted to make sure I did. Thank you.
Any other comments or changes? Can I have a motion to approve?
So moved.
Second.
Okay, we have a motion and a second to approve the minutes. Any further discussion? All in favor?
Aye.
Any opposed? Okay, it's unanimous. Next item is the opportunity for anybody in the public who wishes to speak to the Planning Commission on items that are not on our agenda today. No speaker slips, no one coming forward. We'll close that and move on to the next item, which is a recommendation of the City Council regarding zoning ordinance amendment to allow minor zoning exceptions in ZIRs, based on ZIRs. Mr. Busk, are you giving the report? Or?
Chair Thompson, the report will be given by Susan Reardon.
Okay.
Great. Thank you, Chair Thompson, members of the Planning Commission. As you know, we've been working with the Board of Realtors over several years on improvements to the ZIR process. Back in January of 2014, we established a ZIR working group, and it was composed of some members of the Planning Commission, members of the Board of Realtors, practicing realtors, as well as city staff. And we met for approximately 10 to 11 months and came up with a series of recommendations, one of which was this new minor zoning exception process. So back in February of this year, the City Council initiated an amendment to the zoning ordinance to establish this new process. You may remember back in June of this year, I was before the Planning Commission with an outline of a proposed ordinance, and you provided comments on this outline, and we incorporated those into the draft ordinance. And just last month, on October 13th, we went to the City Council Ordinance Committee with a proposed ordinance, and they reviewed that ordinance and forwarded it to the Commission without changes for your recommendations to City Council. The purpose of the minor zoning exception process is to provide another method to resolve discrepancies or errors in ZIRs that involve minor zoning inconsistencies. Currently, staff doesn't have the authority to waive zoning standards in instances of discrepancies. So therefore, the only option of a property owner, if they were to wish to keep that improvement, is to get a modification. And although we waive the fees for the modification requests in this type of situations when it's a discrepancy, it still can be time-consuming. So we're proposing this new process to give staff the authority to waive some of those minor zoning requirements. But we do realize that there still will be sometimes then there are discrepancies that are involved that the questionable improvement would still need to get a modification. It would exceed the scope of these proposed improvements. The proposed ordinance also includes a list of eligible improvements, and I'll go over those in detail with the Commission so that you'll have an understanding of what we are proposing. This list was made or was originally developed based on our experience with the types of discrepancies that we see in the ZIRs. Also, we reviewed the design review administrative approval process that's currently authorized and got some ideas from there. Also, we reviewed the types of projects that typically don't raise significant public controversy at the staff hearing officer review, and then also with input from your Commission and the ZIR working group. So given that these minor zoning exceptions are processed administratively without notice or a public hearing, it's most appropriate to keep them to minor improvements. The ordinance also includes 5 required findings as well as 4 additional findings that pertain in certain circumstances, and I'll cover those too. So in regards to eligible improvements, they can be categorized into 3 main categories. The first one, unpermitted alterations and additions to legal nonconforming buildings. The second category is as-built additions or expansions of hardscape, landscape, and site improvements. And the third is as-built detached accessory buildings. So in regards to unpermitted alterations and additions to legal nonconforming buildings, that's the largest number of eligible improvements. First, I just want to refresh people's memory of what is a legal nonconforming building. So when I'm talking about these improvements, I'm actually talking the building that was changed, that these alterations occurred to. So in this first picture here, you see an existing house that encroaches into the setback. It happened to be built at a time when the front setback was 15 feet and the interior setback was 5 feet. And then this rectangle here denotes covered parking, and it was built at a time when covered parking could be on the property line. So in this instance, this house is legal. It has a building permit. And after the construction of the house, we changed the zoning requirements. So now the zoning requirements is 20 feet for the front setback and 6 feet for the interior setback. So this house is legal nonconforming. It doesn't conform to our requirements today, but it is legal. So that's the basic idea with this first group of improvements, that the structure that was modified is legal nonconforming. So the first one is the conversion of a carport to a garage or vice versa. And that's illustrated back here where convert the carport to the garage. And this can occur, my screen slide shows it in the setback, but it is proposed to be eligible for a minor zoning exception in the open yard or the distance between buildings. The caveat is that the converted structure must meet the minimum dimensions required or a waiver be granted by the Public Works Department. And that's something that we do now on garages. If they're substandard size, transportation staff reviews it and sees if they can grant a waiver. The next category is over here is convert a garage to a living area. So in this example, the garage is converted to a bedroom. And this can only occur within the setbacks. We're not proposing it as part of this discrepancy to allow it if the garage encroaches into an open yard area, because then you're creating new habitable space in the open yard. As I said, there is 5 required findings and 4 additional findings. One of the additional findings pertains actually to this situation. And what it is that the number and configuration of parking spaces required at the time of the conversion be provided on site. So in this instance, here's the parking area that was provided on site. So since they have the parking area that was required at the time of the conversion, it could be eligible for a minor zoning exception. The next eligible improvement is new windows within the interior setback. Again, we have the house here that's shown as encroaching and the garage that's encroaching. And here's some windows that were added into the encroaching parts. If a window was added in this portion of the building, it wouldn't be subject to this because it's not a zoning violation. It would be a building violation. The next eligible improvement is alterations in the front setback, and this includes facade changes or a new window illustrated here or a new door. That would be an eligible improvement. And in regards to encroaching ground floor additions, those are proposed to be eligible if they're located in the interior or rear yard, if the total addition doesn't exceed 250 square feet. So it's not just 250 square feet in the setback, it's the total addition area, and that the addition did not result in a new residential unit or increase in residential density. And this there's a specific finding for this one too, that the addition represents a uniform extension of the legal nonconforming portion of the building and is generally parallel to the, or is generally no closer to the lot line in question of the legal nonconforming portion of the building. So you see here's the legal portion of the nonconforming building. The addition is just an extension of that. This one is alterations to roof height. In this first example here on the left, this is the permitted situation. The permitted house is 15 feet in height, and the maximum height of the portion within the setback is 12 feet. And the as-built addition, although the house did get 20 feet tall, the portion in the setback only increased by 1 foot. So since this portion is the one in the setback that would be identified as a zoning violation, it could get a minor zoning exception. There is a finding that is specific to this particular exception category, and what it is that the end result, the height of the end result, must comply with the building height requirements, which would include solar access. So we would look to make sure that it complies with the solar access, as well as if there's story limitations. The next one is architectural features. In the first one, it's hard to draw on the slide because this is just a plan view, but cantilevered architectural features such as awnings, cornices, or cornices, they can be located in any setback, and they must be unsupported from the ground below, and that's the definition of cantilevered, that it's not supported from the ground, that it doesn't provide additional floor area, and those types of features can encroach an additional 2 feet into a required setback, but it must be located at least 3 feet from the interior property line and 5 feet from the front property line. And this 2-foot encroachment, that's similar to what's allowed now. If you have an existing building that's built right at the setback, those types of features can encroach into a setback by the 2 feet and not require modification. So what we're basically is allowing is your nonconforming building to be able to do what a building that conforms. The next one is bay windows in the front setback. They must be 3 feet above adjacent grade or finished floor. So you see in this example here, it's elevated. It does not provide additional floor area within the building. It can't extend more than 3 feet into the front property line, and it must be at least 5 feet away from the front property line. Porches in the front setback, they can be covered or uncovered. In this example, you see it's covered. And the landing cannot extend above the ground floor level. So what that means is here you see it's equal with the house. It doesn't mean that the covered element of it, it's the landing. That it doesn't exceed 6 feet wide, so 6 feet wide here by 4 feet deep, and again, it must be at least 5 feet from the front property line. An uncovered balcony can encroach into the front setback if it doesn't extend more than 2 feet and is located, again, at least 5 feet from the front property line. Entrance landings can encroach into the interior setback, again, provided they don't go higher than the level of the ground floor, which this example you can see. It can encroach an additional 3 feet, but it can't be located closer than 2 feet from the interior property line. So that's this example here. And then the size of the actual landing shall not exceed the minimum required by the building code. In chimneys, that's a common one. Chimneys can be located in any setback, and they can encroach an additional 2 feet, but they must be at least 3 feet from the interior property line or 5 feet from the front lot line. And then the last one in this group of the nonconforming buildings involves interior additions that exceed the maximum FAR. And this provision is provided it's contained within the volume of the legally permitted structure. So the structure itself has to be legal. And in this example, it shows a conversion of an attic, but it could be a loft or a cellar. So that could be eligible for a minor exception. The next grouping is hardscape, landscape, and site improvements. And those are allowed within the required setbacks, open yard area, and minimum distance between buildings. And the first ones has to do with decorative features such as mailboxes, flagpoles, or sculptures. And if they're proposed in the front yard, the cumulative total can't exceed 50 square feet of the front yard area. We don't want the whole front yard be taken up with these things. If they want to do that, they can get a modification, but so we wanted to have some kind of threshold. If they're proposed in the open yard area, they can't cover more than 20% of the required open yard area, and this is an existing requirement for other types of encroachments in the open yard area. They're limited to 20%. And this is not applicable to barbecues, exterior fireplaces, or raised fire pits within the setbacks. But it could be applicable if they're in the open yard area, but not in the setbacks. The reason there is that has the potential to cause adverse impacts to the neighbors, and if they want to keep it there, they should go through the modification process and get the neighbor noticed and have a hearing. The next one is attached decks to residences. As long as they're not any more than 200 square feet, they're located at least 2 feet from the interior property line, and again, they don't extend above the finished floor of the ground floor level. So there's an example here. Water features such as fountains, they can be located in the setbacks. And then trash enclosures, as long as they're no closer than 10 feet to the front property line and 2 feet from the interior property line. And this one is another one, this group has a special finding that if they're located in the front yard area here, that they must comply with the corner, lot, and driveway sightline standards established by the Public Works Department, and that is consistent with other improvements such as fences and screens that are proposed within those areas. In regards to as-built detached accessory structures, this slide illustrates a detached accessory structure. They could be eligible for a minor zoning exception if they're located in the setbacks, as long as they're no greater than 120 square feet. They aren't considered a separate dwelling unit. They're not within the front yard, so they have to be in the rear of the property. They're not in the open yard or the outdoor living space, and they were constructed prior to August 1st, 1975. And the last improvement relates to oversized accessory buildings, and they could qualify for an exception if they're no more than 100 square feet over the current size limits. If they're not within the open yard area, they don't exceed the size limits, which again mainly would pertain to solar access, and they were constructed prior to 1975. As I said, there's 5 required findings and 4 optional findings, or not optional, additional findings depending on what the particular improvement is. And the first finding relates to a material discrepancy or error in the ZIR, which directly involves the zoning standard from which relief is sought. And I know at the previous Planning Commission hearing, there was questions regarding what did we mean by a material discrepancy. And material discrepancy is not just a typographical error. It's more of if the previous ZIR didn't call out an improvement, or it didn't characterize it right, and it didn't identify it was a violation, and the current ZIR does, that would be a material discrepancy. If it involved a situation where a previous ZIR incorrectly identified the number of bedrooms or bathrooms, but it did correctly identify a building addition that encroached into a setback, that wouldn't be a material discrepancy that relates to the violation. So the material discrepancy has to relate to the subject violation. The next finding involves the improvement existed on the site in its current form prior to January 1980 or August 1st, 1975 for accessory structures. And the reason why those two dates are different is that in 1975, we made some pretty major changes to the requirements to accessory structures. And since that time, we haven't really made any major changes. And so we have that date for accessory structures. In regards to the date for 1980 for all the other improvements, we believe that if the improvement's been on the site since 1980, it probably truly is a minor improvement if the neighbor hasn't complained about it and that it meets the intent of this process. Also, we did some major zoning changes regarding, we had a major zoning update in 75, and then we did some down zoning, which changed the setbacks requirements. And so we believe if we require the site to be, improvement to be on the site prior to 1980, there's a better chance that it was built to conform to the existing requirements at that time. It just didn't get a building permit. Forgot one step. The last reason is that the city, there was a period in the 1970s where the city didn't issue building permits. It was about 75 to 79. So by having 1980 be the date, we're more confident that if a building permit's not in the file, one probably wasn't sought. So that's why the proposed ordinance contains those dates. The next finding relates to the protection of historic resources, and the finding ensures that the improvement in question would not negatively affect historic resources. And this type of determination is done quite often on development review projects. The urban historian does this. It's a quick check-in with them. So we want to make sure that the discrepancy doesn't affect our historic resources. This finding I covered when I talked about the 250 square foot addition, that it represents a uniform extension of the building line. This finding relates to that the project is in general compliance with the Single Family Design Board Good Neighbor Guidelines, and their Good Neighbor Guidelines talks about privacy, landscaping, lighting, and noise. So in the main two that would be involved in these would be privacy and landscaping, mainly in regards to window placement and stuff. So we'd be looking at screening. In regards to the additional findings, if the improvements in the required open yard or the minimum distance between buildings, that the site will maintain adequate yard areas to provide light and air separation of buildings and privacy and enjoyment of occupants. And this finding just furthers the intent of the open yard area, and it also would ensure that the majority of the open yard area is not encompassed or taken up by buildings. Again, we would use the design board guidelines for this, and it is similar to a finding that's required for the administrative approvals for design review. The next finding, this finding I covered when I talked about the conversion of the bedroom, the garage to a bedroom. So I've covered that one. And then this one is regarding the increase of the height, that it complies with the height limits. And then this one is regarding improvements in the front setback, that it doesn't affect the visibility. So there is also a provision in the ordinance that conditions can be placed on the property if they're necessary to minimize potential adverse impacts on neighboring properties, and those conditions would be proportionate to the potential impacts on neighboring properties. And the majority of the time, this will pertain to privacy and screening, and the majority of time there is fencing or landscaping between the properties, so there probably wouldn't be the necessity of putting conditions on, but the proposed ordinance does have this provision if necessary. The last provision of the ordinance is regarding the action on the decisions, and the ordinance states that the action or the decision is final and effective on the date the decision is made, and this is consistent with all the other administrative approvals that we currently have. The design review administrative approvals, the fence height administrative approvals, and there's some administrative review of solar panels. So this is consistent with those other approvals. Also, the purpose of the administrative review process is to streamline and expedite the approval process and to have an appeal process that would be counterproductive to that. And the idea with these minor zoning exceptions is that we're specifying and limiting the types of projects that could qualify to minor ones. So in conclusion, what we recommend the Planning Commission do is to review the proposed ordinance and concur on the eligible improvements, the proposed findings, and the other provisions of the ordinance, and then adopt a resolution recommending the City Council adopt the proposed ordinance. What the resolution will contain is a description of the ordinance as well as any changes that the Commission may desire. Thank you.
Okay, thank you. Do we have any public speakers for this item? We have one, Rain Stapleman. Hi, good afternoon.
Good afternoon, Chair Thomas and Commissioners. I'm Raina Stapleman, President of the Santa Barbara Association of Realtors, and as you know, ZIRs are an issue that we have all been struggling with for years. The ZIR working group developed solutions to some of the problems of ZIRs, but unfortunately, the overarching problems of reliability and accountability have still not been resolved, with which the grand jury agrees. With that being said, we are here to discuss the minor zoning exception process. We appreciate staff working on creating an ordinance that will help minimize minor zoning issues. Hopefully, this will help alleviate some ZIR issues during the transaction, but we won't know for sure until this process is practiced in the field. We have brought up the following questions to the Ordinance Committee, and so we'll bring them to you as well. To make it easier for the consumer, we feel 1980 should be the year used for both accessory structures and single-family homes, and not have the confusing 1975, 1980. We would like to see 1980 as that benchmark. If a building permit is required, will the fee be waived? For MZE appeals going to the Community Development Director, that we feel is fine. However, for any major issues, we feel it should go all the way up to the City Council for an appeal. We agree with staff that no fees should be charged for an appeal process. According to the ordinance, in order to qualify for an MZE, the discrepancy or error in the ZIR must involve a failure of city staff to properly identify a zoning violation. Who determines the failure? We know of many instances in which the homeowner insists the ZIR is inaccurate, while the city staff insists the ZIR is accurate. Who is correct? What is the likelihood of an exception being granted for a garage or carport that is smaller than 20 by 20? Most of the city of Santa Barbara has original garages that are smaller than 20 by 20, and these are being called out in the ZIRs. We have serious concerns regarding setbacks being called out without knowledge of true existing property lines. As we know, fences and hedges do not necessarily denote the proper property line. Thank you again to the staff for working on this ordinance. We anticipate that our questions will help shape an even better one. We still hold the belief that while this ordinance will help with the minor ZIR issues, the city should make ZIRs voluntary. As always, we look forward to working with you on this issue. Thank you.
Thank you. Okay, we don't have any other speakers, so I'll close the public comment. And any questions from the Planning Commission for staff? Commissioner Jordan.
Thank you, Mr. Chair. Just a couple of questions. But first, I'll run off on a tangent because I never pass up on the opportunity to embarrass Ms. Reardon. So imagine at the start of that presentation, somebody was saying, I'm not going to do that. And then halfway through that, they're saying, I don't want to do that. Then at the end of it, they're agreeing to do it. That's something I get to watch every couple of weeks on Wednesdays. She's the staff hearing officer. And I just can't tell you what a great education I get each couple of weeks from watching that and having her also be part of this process, because I think what's going to be key in this is the person that's doing it, and I'll burden you with that, my vote right there. But I see I see in that presentation of all those graphics, I see your handprint on those, and I just want to say I really appreciate that, and I think you're the perfect person to explain this to us. So, a couple questions on page 2, where you talk about what the eligible improvements are. When we get to things that you haven't anticipated or we haven't come across, what's going to be the process for adding to the list, to tangibly add to the list of a structured eligible improvement so that it becomes a qualifier rather than a discussion on qualifying? How's that going to work?
Well, at this time, the way the ordinance, since it's all in ordinance form, it would have to be one of these lists.
Right.
Or in some of the instances, I don't know how appropriate it would be. Sometimes in the ordinances it says or similar improvements. We put that word in there so that we can make the leap on how we can approve it or improve the minor exception.
So when we structure it in an ordinance form, the only resolution is to come back and revise an ordinance, right?
Correct.
Yeah. So maybe you can think about that. Maybe as you keep looking at Scott, maybe we can have some discussion on how that would look when something that's unanticipated actually becomes something that comes up again and again and again.
Go ahead.
Go ahead. You know, okay, or I'll just go on to my next question and let you guys work on that. And then your reference on top of page 3, the process of streamlining in this process. Can you just briefly explain what that looks like as you envision it versus what the alternative would be, and how what streamlining actually is going to look like on the ground from a user perspective?
Okay, Chair Thompson, members of the Planning Commission. So your question relates to the building permit process?
Correct.
What we've been doing is in these instances of discrepancies and also in the instances of violations when they're in the escrow period and the buyers and the owners come in all stressed out, want to figure out how do we abate this violation. I've been meeting with the supervisor of Plan Check, Lonnie Cassidy. We meet together with whoever's interested, if it's the agent and the property owner, and we discuss the violation and what type of information is going to be needed for abatement and the fee. And what that does, it reduces the person jumping from counter to counter and they're going right to the top, because I'm the supervisor of the zoning enforcement, the ZIRs. And so that really expedites it. It gives them an action list of what they need to do. And it reduces the amount of information. If I'm not available, then the ZIR preparer would sit in the meeting, and they've gone out to the site, so they really know in detail the violation and what kind of information we'd need.
So do you see that being a structured protocol rather than I'm involved with it, so that's the best way to do it? So then that's when we say we will end up streamlining, that will be the process that we follow?
We have been doing that, yes.
Okay.
We've implemented that, and we've gotten positive feedback on that process.
Okay, thanks. Thank you, Mr. Chair.
Thank you. Any other questions? Commissioner Peugeot.
Thank you. First of all,
A representative from the Board of Realtors, in speaking today, brought up a list of items, some of which I would also like to know what staff would respond on these. I also had the question about the difference between 1975 and 1980. I understand where it came from. I also think it's a good idea to use some sort of justification as to why you pick a certain year. But it does seem a little awkward that for some portions it's 1975 and others it's 1980, and there's only a 5-year difference between them. So I would like to hear a little bit more from staff on that. And there's some other points that were brought up too that I would just like to hear a little bit of elaboration from staff on. So it came up a question about fee waivers, the issue about appeals that I think we've talked about before, and then two other ones. One is, what about a garage that was built less than 20 by 20? That one I don't recall of us having really discussed before. And then also the true lines of the property line. And on that last one, let me just say that from my perspective, that one I do feel clear about myself, and that is that the exact location of the property line usually takes a new survey to determine it, and that's often the case in all sorts of processes, whether you're buying and selling a property, doing a new easement agreement, and getting a permit from the city. Oftentimes you end up having to double check exactly where that property line is. So I don't see this particular process being unusual enough that creates a problem. But on the other ones, I'd like to hear from staff.
Thank you, Chair Thompson. Commissioner Peugeot. So in regards to the appeal process, staff's not recommending an appeal process. We believe that that one is not necessary. We haven't had discussions on waivers of fees, but in regards to the fee for this new minor zoning exception process, we're not proposing to have a fee, and we discussed that with the ordinance committee, or I brought that up at the ordinance committee, and they were supportive of that. And that's along the lines that City Council gave us the direction of, in the cases of these discrepancies, that we waive the planning fees. So if a project would qualify for a minor zoning exception, we wouldn't charge a fee, just like if they need to get a modification. If they didn't qualify for one of these exceptions and they did need to get a modification, we waive that fee. I haven't had any discussions regarding waiving any potential appeal fee since we're not recommending one. That's a discussion that council would have to decide. I don't know if that falls under the same category as these discrepancies or not. So in regards to the fee, that's our recommendation there. The garage and the carport, the minimum dimension of the garage. If there's an existing garage on the site and it is let's say it's supposed to be a 2-car garage and it's 16 feet by 16 feet. Yes, we may call out that it's non-conforming. It doesn't meet the minimum size requirement, but it's not a violation. And so this isn't going to pertain to that. What it pertains to is if there was an alteration to the garage or carport. If a carport was changed to a garage, then we want to make sure that it has the minimum dimensions to function as a garage, because the dimensions for a garage the width of a garage is greater than the width of a carport. So we want to make sure it still functions as it was permitted. So when there's this fear now that if a garage is not 20 by 20, we're going to be calling these additional violations out. We're not. We just note for the record that the garage is non-conforming, just like we note for the record that the building's non-conforming to the setback or to density. It's just a non-conforming situation. Regarding the property line, that's correct. Without a survey, we don't know where the property line is. We use the best information we have, whether it's a site plan or site improvements. That's similar to the modification process. But I think this process would help in that if it appears to be in the setback, they can get this eligible improvement or this minor exception process for it. So, we do hear that from property owners that the fence line isn't the property line, but without a survey, we don't know for sure. We're not going to be requiring surveys for these minor projects. And then, was that all? Was that all the ones you were asking?
Well, the question about why not merge the two dates together and use 1980. I mean, what kind of a negative effect, or what would be the downside of doing that from staff's perspective? Because I understand the justification for the two dates, but I also don't understand what the downside might be if you just use 1980.
Well, yeah, I mean, there's just a clear line in the sand that 1975 was when these major changes were made. So if it was built in 1978, it wasn't, and it's in the location that doesn't conform to today's standards, then not only is it a building violation, it is a true zoning violation. Whereas if it was built before 1975, there's a chance that it could have conformed to the zoning standards, because there was several ordinances before then that changed the provisions for where a accessory structure could be located on the property. It could never have been in the front yard, but in regards to the backyard. So it's mainly for that. It's, we're going on the premise that if it's before 1975, it may have complied to the zoning standards at that time, whereas the other provisions, when we say 1980, there's other reasons for it. But that's something the commission can decide. I don't know if Mr. Vincent wants to add anything else to that.
Mr. Chair, the only other point I would make is that the amount of confusion I see coming out of these two dates is minimal. It's either you're dealing with an accessory structure and then the date's 1975, or you're dealing with everything else but an accessory structure, then the date's 1980. It just doesn't seem that confusing to me.
Okay, thank you. And I have one more question. And I'm looking at the draft ordinance, and there's two sections involved. One at the bottom of the page, capital B1C, and then on the top of page 2, section B1D. And I have a question here in the draft. So in section C, it talks about encroaching first-story windows. And I understand what the provision is trying to accomplish there, but it's limited specifically and only to first-story windows in the house. And then in section D at the top of the next page, it talks about similar items, but only those that are in the front setback. And in section D, it basically says if it's a window, door, skylight, or facade change in the front setback, you can get a minor exception. But for the other setbacks, it only includes windows. And I don't understand why the interior and rear setbacks would only be limited to minor exceptions for windows, whereas the other ones you could also get a door, skylight, or facade change.
Commissioner Thompson, Commissioner Perdue, that's actually a really, really good question, because we've had debate with this amongst staff. And actually we had debates amongst staff with the new zoning ordinance, because this question's come up. You are correct that number C only allows first-story window changes, and the concern there is with these minor exceptions is if it's on the second floor, that's more apt to cause conflict with the neighbors in regards to the good neighbor policies with privacy mainly. A lot of times when the staff hearing officer is reviewing projects for second-story additions, the main comments relate to privacy and the window placement. And so there is the argument, well, what difference does it make? Because it's been there since 1980. The neighbors had to deal with it all this time. Well, maybe the neighbor thought it was a legal window, and so they didn't complain about it. They didn't know. But now, had they known that this window that overlooks their outdoor area is as built, it may be something that's more appropriate that they receive a notice for and come to a hearing if there's some concern. So that's why that's limited to first stories. And then regarding the list of improvements under D, that can those improvements can occur on any floor, whether it's the first story or second story. And so, why don't we allow new doors within the interior setback? I don't know, as a staff hearing officer, that I have ever improved a new door within an interior setback because of the early on when I became the staff hearing officer, the comments I've heard from the neighbors is that the lighting, the in and out, all that kind of stuff right next to the property line is an annoyance to them. Also, a lot of times when I look at modifications, I look, is it a necessary improvement? Do they really need it? And a lot of times the door in the setback is not really necessary. It could be relocated somewhere else out of the setback. Every room in the house doesn't need a door. So that's why I was not proposing to include doors within the interior setback. I believe that's something that should require a modification so the neighbors could be noticed for. And then in regards, I don't know that we've really seen any significant facade changes on the interior setback. It's mainly to make it more street friendly and appealing.
Well, particularly on the facade change, I mean, just throw out there of all of them, oftentimes, if you do a facade change, you really should do it to match the rest of the house. So maybe the facade change is in order to match something on the rest of the house, or maybe it's to match a change, if you do one on the, for the front setback, maybe it makes sense if you're going to allow it there that you would allow it on the side too, so that you don't have mismatched
but that
segments. That one seems to me a little bit strange, particularly, but maybe there's more discussion later. I understand what you're saying. I certainly understand about second-story portions, but personally, I still think I would be a little more open myself to at least the doors and the facade changes on the other in the front setback.
In the front or the interior?
The interior and rear setback.
Allowed doors, new doors without a modification in the setback, interior setback?
Right. Merging that part. Okay, anyway, that's for discussion later, but those are my questions. Thanks.
Thank you, Commissioner Schwartz. Questions?
Yes, thank you. I have a few questions for Ms. Stapleman, if I could ask you to come back up, given how long the working group was together, and I was a member of that. I appreciate a few thoughts. A few things you mentioned I wanted to query you a little further. On the issue of fee waiving, what I heard from Ms. Reardon is that there will not be a fee associated with this exception process. Did you have something else in mind?
No, we did not. No, that was not.
Okay, so we've cleared that up there. Mm-hmm. Okay. Then you mentioned beyond appeals, if there is an appeal process going to the community development director, another level of appeal to city council. Could you tell me what the association is thinking of there?
So if there was something that maybe was thought to be a minor, zoning infringement, but it really became something larger, and so then you don't have a continued appeal process. So you wouldn't allow that homeowner to say, hey, wait a minute, we want you to really look at this, and if they're not happy with that decision, that there is someplace else for them to go outside of the community development director.
Okay, and if a fee were involved there, has the association contemplated their position on a fee for that level of escalation?
Well, we feel that there shouldn't be a fee because many times there are issues that come up that a homeowner has not created, and so they're being brought in to defend themselves when they haven't done anything. So we feel that there should not be any fee. I mean, again, you're asking the homeowner to prove their innocence, just like with, where is the lot line? Surveys are normally not done when a home is purchased. Occasionally they are if there's a question, like a tree is in the middle of the line, and they're like, well, is this tree on our property or is it on the... They may have one line shot. But normally it's not something that is done. But if someone is coming from the city and calling out things as violations and they don't know where the lot line is, again, the burden now becomes that of the homeowner to prove where their lot line is.
So what would you, as we heard from Ms. Reardon, that surveys are also often not available or have not been
They're
conducted
expensive.
for many years. So is there a proposal from the association about how to handle that question of the property line relative to if there's a disagreement on a setback vis-a-vis property lines?
Exactly. If there is, some kind of major, zoning discrepancy, and it's maybe 2 inches, which we've seen has cost someone thousands and thousands of dollars, that the city provide that survey and prove where that line is. Mm-hmm. Because, the homeowner had purchased it, thinking everything was fine. It hadn't been called out before. Mm-hmm. So now it's being called out, and they're like, well, wait a minute, where is that lot line? If you're calling out something that has a 2-inch leeway, I would think that there would be some kind of discretion to say, look, we think it might be 2 inches, but this really isn't a big deal. But apparently it is, and it's causing people great amounts of money.
Okay, thank you. So, Ms. Reardon, let me turn to you sort of in connection with Ms. Stapleton's further comments. Are you looking today for the Planning Commission specifically on the question of appeal process? Looking at page 5 of the staff report. There's a reference to the previous Planning Commission discussion, and then the question if an appeal process was established or were to be established, and you go on from there. I don't know if you've discussed this with Chair Thompson, if you're looking for feedback specifically on an appeal process today. I don't know that we're going to do straw polls. I'm not quite sure how you're looking for us to provide feedback, and on which categories, which specific items. But this would be one thing I would be interested in, whether or not you want feedback today on that.
Sure, Chair Thompson, Commissioner Schwartz. Yes, what we want you to concur on is the eligible improvements, the findings, and the other provisions of the ordinance, which would also include the appeal process.
Okay.
My listening to Raina's comments seems to be that they're envisioning an appeal process of the cited violations. That's not what that would be for. This is only for the minor zoning exception approval or denial. Mm-hmm. And if there is a way, sort of informal appeal, if you get denied for your minor zoning exception, you can apply for a modification. And that modification is appealable to the Planning Commission and to the City Council. So you can get up all the way through that process. So, in this description that if the improvement's 2 inches in the setback or not, that's not going to be the subject of the appeal. That's part of the ZIR process in identifying violations. What an appeal process would be only on the decision on these improvements, on the decision of these improvements. So it would be similar to the decisions that the Planning Commission makes. So it's not, when I'm hearing it, I hear confusion between what the appeal would actually be on.
Mm-hmm. My next question for you is on sort of who identifies or would generate the material discrepancy information. Again, Ms. Stapleman brought this up. Do you have some thoughts or response on the notion of someone, in addition to staff, identifying a material discrepancy, since we're talking about a two-way situation? It's the city and it's another party or plural parties sometimes. So how do we look at this a little more holistically is kind of where I'm going with my question.
Chair Thompson, Commissioner Schwartz. Again, I think that is the dispute in that instance that comes up is a disagreement on the identified violation.
Right. Mm-hmm.
And so, I had a total mind blank.
So I guess, let's kind of lay this out.
The
staff identifies or staff issues information that allegedly uncovers a minor zoning violation. Mm-hmm. And then there's a response to that by an external party, the property owner, I guess it'd be likely the property owner. So it's a responsive kind of defensive posture then, we've discussed this in the working group, that the non-city party would be working with. And, well, I guess I don't know where else to go with this other than.
Yeah,
Mr.
no,
Chair.
I understand. Oh, go ahead.
If I can jump in here for a second. I'd like for the Planning Commission to consider what the purpose of this ordinance and what the purpose of a minor zoning exception is intended to do. This is intended to be a way of resolving that impasse between staff's position saying that a violation exists and a property owner's statement. My prior zoning enforcement report or information report didn't call that violation out.
Right.
You shouldn't call it out now.
Yes.
So there's that impasse.
Right.
This is not going to correct that impasse. What it does is it is a tool to get beyond the impasse by making a minor zoning exception. The condition of the property vis-a-vis where the house isn't changing. Where the property line isn't changing. What it's changing is that the city is declaring a violation exists. If the property owner gets their minor zoning exception, it's the same as getting a modification. The nonconformity with the zoning ordinance doesn't change, but the status of the property once the minor zoning exception has been granted is the same as if the property owner had gotten a modification. The process here is much more streamlined compared to the modification process.
Okay, thank you.
And the only other comment I want to make at this time is Ms. Stapleman mentioned about the fees and your inquiry about the fees. Her response the second time mentioned it was referring to fees for the minor zoning exceptions. Her first statement was a request that the Planning Commission and the city waive any building permit fees associated with corrections, and that is a decision for the City Council to make at some later date.
Okay. So then, just sort of, I think almost in wrapping up here, speaking of discrepancies and an impasse, so we are talking about identification of property lines. So where we don't have, so I guess I'm looking for staff's feedback on this, where we don't have proper documentation. The property owner doesn't have it, the city doesn't have it, there isn't a survey, but we're declaring or alleging that there's a violation, let's say, of a setback issue, encroachment into a setback, but we don't know where the property line is. How are we supporting or defending the alleged violation if we don't actually have documentation as to where the property lines are?
Mr.
You
Chair.
see where I'm
Yes.
going with that?
And I,
Yes,
again,
some of my
I would
colleagues
answer.
are nodding, so they.
I'd answer this question the same way I answered tried to frame the issue here is, again, this is a tool to get past an impasse. If you have Ms. Stapleton's circumstance where the alleged violation is literally 2 inches, the exceptions allowed in this, either interior setback or front setback, allow 3 feet. All of a sudden, the 2 inches don't matter. The 2-inch situation is resolved. 1.5 feet is resolved. Up to 3 feet of question, the gray area, is resolved. And if you want to go beyond that, then get a survey, and then we can figure it out. We will know what the issue is. But again, the minor zoning exception is intended to be a tool to quickly get past these minor zoning exceptions and the minor violations that are called out. This is just one part of this process.
And then I have 2 questions from the slides, Ms. Reardon, if I could. I don't know that we have numbers. Oh, yes, slide 10, which is entitled Architectural Features, if we could take a quick look there. I was just wondering if we have specific definitions or concrete definitions, porch versus landing. When I look at these photos, see the upper right is porch, and then the bottom down there is landing. So are these general examples that you're using, or are these specifics that will be embedded in the new language you're looking for approval on? Because I don't see much of a difference between porch and landing here in these photos. And I think it's, as much clarity as possible is important for app.
Chair Thompson, Commissioner Schwartz, Allison is looking up the definition. We do define porch, and we do define balcony, and we do define
landing. I mean, they look like several low-level stairs to me in both cases.
Okay, well, in terms
there's a
of
covering on the porch, but it said I think you said we don't always see the covering, and that's sort of immaterial, but it's these other architectural features that could trigger a minor zoning violation.
Okay, well, we have a definition of porch. In terms of a landing, it has to be uncovered and unenclosed. If you look at page 2 of the ordinance, it says in the front, halfway down, in the interior setback, an unenclosed, uncovered entrance landing and outside steps not extending the finished floor. So this example right here would not be, this would not be a landing. It's a porch. It has a covered and all of it. A porch, generally, it is wider, where you can sit on it and enjoy passerbys. But since it is encroaching in an already encroachment, we wanted to limit the size. A landing, since it's in the interior setback, it wouldn't be covered, and it would meet the minimum size required by the building code. So I don't know that that's much of an
Okay.
problem.
What I'm going to do is, Mr. Chair, I sense that you want to move this along, and I understand that. Let me just say, if this is not the right forum to go over the details, then I would suggest another forum be scheduled, because with the number of years that the city and the association and, the standing room only public has been here talking to us, I think getting the details right are important. I'm willing to close out on my questions and my remarks today, but I think we do need to look at this in detail. If you want to reconvene the working group, I'm happy. I don't know if my 2 other colleagues are, but if it's not for the full commission to take up in a public session like this, then I suggest we take it up in a closed session and then bring it back to the full commission. But I'm going to close right now because we have another item today. At the same time, I don't think that we have gone through the entire set of requests with details appropriately. So I'll probably just be making some general comments at the end. Thank you.
Thank you. Commissioner Higgins, questions?
Yep. 2 questions. Just take me back here for a second and tell me what the city's position is on outside of this process. If there's violations found, does it stop escrow from closing? And if it doesn't, what happens to the buyer if they do close escrow?
Mr. Chair, members of the Commission, the city does not have any control over whether the escrow closes or not. That is up to the 2 buyers, the buyer and the seller. The existence of the violation and it being called out in the ZIR may influence those decisions on those third parties, but we're not a party to the escrow.
Okay. So in other words, this can be characterized as a disclosure process by and large, and the violations stay on the property after the process, regardless of the escrow. So my next question is, help me get my head around the requirement for finding number 1. The process appears to only be available if there was a prior ZIR. Have you thought about the process being available to owners or applicants if there's a discrepancy without the benefit of a previous ZIR? Or does that undermine the whole thing?
Chair Thompson, Commissioner Higgins, it would apply whether there's 2 ZIRs or 1 ZIR. If there's an error that's 0 ZIRs, well, then that's just a plain zoning violation. I don't understand.
But what if there's a discrepancy? How do you, so you may still have a setback discrepancy in the mind of the property owner and the person doing the inspection where there were no previous ZIRs, so you still have a discrepancy. Is this process available for that scenario?
Mr. Chair, members of the Commission, if truly there was this is the first ZIR for the property, it's prepared. Presumably it was prepared in good faith and with we're dealing with the 1 ZIR in front of us. Yes, a property owner might have a disagreement. They will bring their evidence to the staff. They'll explain their position, saying, no, I don't agree with your conclusion here. Staff will evaluate that, and he either will accept that, oh, I wish I had that evidence when I made the report, but I didn't. Now I have it, and I changed my conclusion. The discrepancy between two reports, the reason why this is addressing that situation is we can't unring the bell of the first ZIR. That ZIR was issued years ago. It was presumably relied upon by the current owner, then buyer, and now current owner, now prospective seller, is saying, hey, I was told by the city I didn't have any violations when I bought my property. Now the city's telling me, even though I haven't changed my property at all in the last 20 years, and we just can't unring that bell of what the buyer relied upon. That's why this tool is being proposed to help resolve some of those problems.
But you still have an opportunity. It still seems, though, that if you don't have a past ZIR, this process does address some minor problems with properties in the form of a process before staff or the director that opens up the opportunity for those alleged discrepancies to continue to exist without violation that could be taken advantage of by non-ZIR properties.
I could add to that. And I turned myself off. I don't know which of you commissioners are on the new zoning ordinance committee, but an expansion of this process is being looked at as part of the new zoning ordinance to expand the types of projects that could be eligible for administrative zoning relief. So it wouldn't need to request a modification before the staff hearing officer. So that's being discussed now. So that would be appeal or useful for new development, as well as abating violations if they fall within that parameter. So that's something that's being studied now, and it'll be part of the new zoning ordinance.
Thank you, Commissioner Campanella. Questions?
Thank you. Thank you for explaining the modification process, as well as that's an alternative if an individual this minor zoning exception is not granted, they have the right to ask for a modification. Now, that could be a standalone request, or also could it be a request, let's say, when they come in to rebuild or redo the product in some way, they previously, let's say they previously had the exception. Now when they come in for a new building, perhaps it gets to a point where the exception would not be appropriate in the minds of the building department or the design boards. Would there be in that case, do they have a wild card that says, well, I got a zoning exception before, so I can keep it? Or based upon the nature of what they want for approval, that could be taken away?
Thank you, Chair Thompson, members of the Planning Commission. It would be similar to a modification in that it would run with the land. So if you got a minor zoning exception, it would still be valid unless you're making changes to that. We'd have to look at the scope of the changes to see if a new modification would be needed. But it runs with the land.
It runs with the land, okay.
Mr. Chair, I'd like to expand on that answer a little bit. Yes, the modification, or in this case, a minor zoning exception, will run with the land. It will transfer along with future buyers of the property. In your hypothetical, you were saying, what if a future property owner comes in, wishes to have design review approval for modifications, changes to the house? I don't want to use the same term. The discretion of the design review body is such that they could say, the combination of that modification or the combination of that minor zoning exception as well as your additional improvements that you're proposing is too much, and they could say, we just can't get there with you. Your proposed additions need to be less because you already have this exception over here on this side, and the combination of the two is just too much. They still have that discretion. It doesn't go away. The property owner could withdraw their application if they like the exception better than they like their new proposed improvement. They could walk away from the application and say, I'll keep my exception. But it could, there's no guarantee that they will get to a design review approval with the combination of whatever they propose.
That's very clear. Thank you. I guess the only other question I have, most have been answered, thoughts that I had. The grand jury had recommendations, or I don't know if you call it recommendations, or suggestions or criticism. In the specific minor zoning exceptions part of the ordinance that we're looking at, is there specific suggestions that they had on this that we're now complying with, or was it mostly the items unrelated to this, bigger picture issues?
Mr. Chair, I'll take a shot at it first. I don't think the grand jury was aware when they did their investigation that the city was considering minor zoning exceptions. Yeah. So I'm not sure if they had any. I don't recall any specific comments. I could try to go back and find the report, but I think that at least in part, minor zoning exceptions is one step that the city is taking, trying to address some of the issues that were raised in the grand jury report.
Thank you.
Okay, thanks. I have a couple of questions. Ms. Reardon, on your slide talking about number 5, required findings, you talk about improvement is located in general compliance with the SFDB Good Neighbor Guidelines. I'm not sure the word located is applicable there, but my question is, how do you determine in general? That seems to be an awfully subjective term. Who is going to determine in general? Have you thought about how you were going to deal with that?
Well, it's kind of like a compatibility determination. The person who's going to be making these findings is the person who's going to be granting the MZEs, which at this time it will be me. It will be a higher level staff, and so I don't know, Scott. Can you give a better?
Mr. Chair,
my question is, like a lot of times when we start talking about these squishy subjective terms, you open the door for difference of opinion as to what's, quote, in general, unquote. And so I just was wondering how you propose to determine in general. 90%, 70%, 51%? I mean, that's
true. And that is a challenge. However, that's the same challenge that is that the SFDB deals with every day. Granted, this finding will be made by an individual as opposed to the SFDB, but we looked to that process. We looked to the findings that the SFDB makes, and staff, both the staff hearing officer, the senior planners who man the staff hearing, or woman the staff hearing officer. I'm not sure if we've ever had a man as a staff hearing officer. Their experience guides them, and the guidelines themselves explain how to come to that conclusion of general compliance, which is actually the finding that the SFDB, the SFDB findings refer to general compliance. So I would say if you're trying to find a mathematical percentage, that to me that's 51% or
I just
more.
use that as an example. For any of these subjective kind of words, it does tend to open the door for differences of opinion as to whether something does or does not comply. I understand it's a discretionary decision, but
yes, and again, while we're not recommending an appeal process, the modification process remains available for most of these situations. And so if they were looking for having a process where a body greater than the individual decision maker in this case, if they were looking for more eyes to be looking at that decision and coming to a different conclusion, that process would remain available for most of these eligible violations.
But not a MZE, it's not appealable.
That's true. We're not recommending an appeal.
Okay, one other question. When you talk about garage conversions, you say the number and configuration of parking spaces has to comply with what was required at the time of the conversion. How would you know when the conversion occurred? Since theoretically we're looking at a discrepancy between a ZIR at some point in history and a current ZIR? How do we know when this garage conversion occurred so we know whether it complied with what the requirements were at the time the conversion happened? If we knew when it happened, wouldn't we know how to have dealt with it at the time?
Well, if we knew when we do it through research. There's a number of different materials that we use to reach conclusions. One's the sandboard maps that has indication of what's on the property, aerial photos. There's also the county residential building record, which is when the assessor's office went out and did assessments of the property, so we can get a general idea of when the improvement came on site.
So you do have, in fact, some tools to try to narrow down when this happened, and then you can see what the zoning ordinance required at the time.
Correct.
Okay. The other question that was raised by Ms. Stapleman is, I think she raised it. What do you do? Who makes a decision when there's a difference of opinion between what's raised in the zoning ordinance and the staff? Who makes that decision? Is it going to be the staff person that makes this MZE determination? Is that where it resides?
Are you talking about during the preparation of a ZIR or with the...
Yeah.
During what there is what happens when the ZIR preparer goes out and finds something that seems to be a violation or a discrepancy, and the realtor brings it up, or they issue the ZIR and either the agent or the property owner doesn't agree with it, they contact the ZIR preparer with additional information. And if they're not satisfied with the outcome, then they bring it up to my attention and I review the submitted information and the ZIR and make a determination. So it's a kind of an appeal process. We ask that they do it within 10 days since that's when the information is real fresh and everything. But they can come back years from that date, 3 years later, and provide information and say that conclusion was wrong. We found a building permit, or here's an old site plan stamped by the city, or some information that shows that that's wrong, and we'll change it. So the determination is first made at the ZIR preparer level, and then it's elevated to the supervisor level.
Okay. That being the questions, we'll have our discussion now. In your staff report, you asked the commission to, Commissioner Higgins, you have some additional questions? Oh, I'm sorry. In the staff report, you asked for the PC to discuss and concur with the list of eligible improvements, the list of proposed findings, the provision for conditions of approval for the MZE finding, and then discuss the option for appeal of MZE decisions. And then you wanted us to adopt a resolution to forward to the City Council. So with that, up to the Planning Commission for discussion of those items. Commissioner Peugeot.
Thank you. First of all, this has been a very difficult project to work on and has been months and months in the works, and I want to commend staff for their persistence and diligence in producing rather understandable document given all the different places all of our discussions have gone over the last couple of years. I think the ordinance draft is good. I only have one comment that I would like to see as proposed change, and it gets back to those encroachments in items B1C and D, particularly in B1C, which is the bottom of the first page. So just to be a little more clear, that now is entitled Encroaching First Story Windows, and it says if a building encroaches into an interior or rear setback, the addition of a new window or the enlargement, basically, of the windows on the first story can be granted a minor exception. In reviewing this and listening to staff's responses, I do not see any reason why a door could not also be included into that section if the window provides enough opportunity. I don't think a door is really any different in terms of an encroachment in these areas. We're talking about something that's been there since before 1980, 35 years or more, and was missed on a prior ZIR. I don't see a distinction between doors and windows for that provision, and I would like to see doors included there. The second part of that gets back to the facade. And actually, I think this, if it were drafted, would need to be maybe its own item, because I don't see how it could be slipped into item C. But I think it's, in a way, silly to me that you could accept a facade change on a front setback, but not accept that same facade change on the side or the rear. And from a design perspective, it doesn't make sense to me, because if somebody had changed the facade on the house and you, through a minor exception, agreed to let it stay on the front, then that causes them to remove that same facade change that was extended to the side in the rear. I mean, that doesn't make sense to me. So, so if you're going to allow it at all, I would propose that you would allow it on any side of the building, for nothing else, for consistency purposes. Those would be the two suggested changes, and the only two suggested changes that I would propose for the ordinance draft. Thank you.
Thank you. Commissioner Higgins?
So I sort of agree with Commissioner Schwartz that this is potentially too complicated for us to completely, or at least me personally, to buy off on today. So I'd encourage staff to set up another working group and come back and unpack this thing, perhaps with some more participation by the realtors or even contractors. But if we can't do that, I don't know that I can support it today. There's a couple things I would change. I do think that sort of based on what Commissioner Jordan maybe hinted at, is that we're setting up a process here that probably, well, is it's possible there may be some unintended consequences or things that we haven't discovered yet. So I would be in favor of either having a sunset on this new ordinance 2, 3, 4 years, or building in an appeal process, so that there's a way to iron out those things that are going to come up, because this is a great effort by staff to attack a problem that frankly has been created over for a lot of different circumstances. But I sense that the approach to this is going to maybe uncover things that are unintended, at least at this point. For example, if we can't do that, then maybe coming back to the points I made at the last hearing about putting things in the code that are components to a home that don't warrant any inspection, according to this routine. So I know that that's sort of an inverse way of looking at these things, but I think it will help educate the public about what matters and what doesn't matter. And I think if we ought to be reminding ourselves and our customers that it really is about the original intent of the code back in the 70s or 80s to regulate additional bedrooms or garage conversions. So I would be in favor of having the same date, 1980. I totally appreciate Mr. Vincent's explanation, but I think in the interest of just educating people that aren't in the business, 1980 is a cleaner way of doing it. We should be expanding the opportunities for people to take advantage of this administrative relief and not narrowing it or making it a little bit more complicated. I would love to see I think the realtors and the customers of this process really have a hard time still with the building permits that are required as a result of these discoveries, and those can be the most difficult to resolve because you have to get involved in x-raying foundations or other invasive techniques to determine whether or not things are built to code. So if there's a way to include a provision in here that building permits are waived on some of these things, if they can get through the administrative review process, that may be difficult for staff or a city attorney to embrace, but you always have the opportunity to come back, excuse me, to apply for those building permits when you want to come in to apply for new construction on your home. So those building permits could then be applied for later. I also support the notion either that we remove setbacks out of this process or allow them to, potential setback violations to exist outside of this process, or that the city needs to pay for that. And I also support removing finding number 1.
Thank you. Commissioner Lodge.
Thank you, Mr. Chair. This is an ordinance that handles a limited number of conditions where there's ones in which there's been an error made in a ZIR, and it's a minor issue that is being resolved. It gives that is being addressed. It seems to me this gives a tool, provides a tool to take care of that and get everything put in order. I think that I agree that there should be conditions. And those would all be on a case-by-case basis, and there is the option if someone gets is unhappy with the decision, that they can go for the route of a modification. And so I really think this has been hammered out over many weeks, and I think that it's something that I'm certainly ready to support sending on to the Ordinance Committee.
Thank you. Commissioner Jordan.
Thank you, Mr. Chair. So, I've had a lot of trouble getting my hands around this as a process, and I think you guys staff has continued to keep making the same point, which I think has helped me that, it's not necessarily, it's not a method to resolve on-the-ground violation. It's a method to resolve the city's inability to recognize it at a prior time. Philosophically, I think I'm still with Commissioner Higgins a little bit that, this whole date issue and the city's goal here is more resolving that focus rather than actually being a little more practical and recognizing that in 1990 maybe somebody did that too, and it's still a material small deal on the ground, and should we resolve that? Now, I missed the last NZO meeting, but I'm going to pay attention better at the next one because I like your answer that exactly what we're seeing here should be front and center on the topic of the NZO process, and I agree with that, and I appreciate that answer, and that pretty much resolves how I see my issue with, are we just being punitive, or are we just answering only to what we perceive as our liability, but we're not being practical about 5 years later what was on the ground also. So I agree with Commissioner Lodge that in general this is a supportable document going forward. If there's traction up and down the table, I would still, for just the reasons that were even talked about in the difference of one person making a decision, and although I had all those wonderful things to say about Mr. Reardon earlier, but just one person making a decision versus the compatibility issue, say, that's determined by 7 people sitting at the single-family design board. Each of those people have a different frame of reference, different life experiences, different view of what compatibility is, and at the end of the day, then they come to one decision that represents all 7 of them. And same thing too with if somebody goes through this process and is left with the result of one person making a decision, but still feels that they have a case, I could support my version of an administrative appeal, and that would be, all the evidence has been made already. The applicant writes a letter, and the city responds in a letter. There's not another hearing. It's just if it's at a person, if the initial decision's made at, say, the level of a staff hearing officer, there's still disagreement there. The applicant writes a letter. The community development director responds with a letter. He just reviews the same information, looks at the hearing, whatever. Very, very casual administrative process without the burden of another hearing, without money, without anything, and that's the end of the road. And I think that offers a little bit of a protection that if you got out of my comfort zone on who that person is in the process, and if they don't have the capabilities of what I think the current staff hearing officer has versus it's a different person who doesn't bring all those tools to the table, then there's still a method for an applicant to follow up on an appeal. I really think that's my only, and my other suggestion too would be my earlier question on what happens when we find out a situation recurrently comes up that's not on this list, this 3+ list of items that are eligible. I just know once you write an ordinance or once you redo an ordinance, the city's pretty reluctant to open that up pretty quickly again and fix an ordinance or revise an ordinance. So, if there was a way to at least, and I don't profess to know what the answer is to that question, but if there's a way to at least make this that the language represents the broadest interpretation of eligible that the city can accept. And if this is it, okay, I'm all right with that. But if there's another sentence or two that can be put in there that allows that greater broadening of interpretation in this process, I would support that too. Thank you, Mr. Chair.
Thank you. Commissioner Campanella.
Thank you. Let's see. I think what's been accomplished, excuse me, for the minor zoning exceptions is that a part of the process has been to split. When we first started reviewing the ZIRs, was a bifurcation of major and minor, and trying to distinguish between the two, and that's been accomplished. The other is, if I recall, something happens that's not the fault of anyone. There was an oversight, or it's neither the property owner or maybe the staff person at the time realized something, or maybe it was an honest mistake. And then also that the discrepancies can be more than a nuisance, but also hold up closings, et cetera. So I like the idea that we're making progress in an area that seems like it's a pretty fix that could be handled, and it gets one of the major irritants and one of the major conditions, I think, out of the way. I don't know what the volume is on minor discrepancies versus major issuances, but I think if this number is significant, the fact that we have a mechanism to solve it, there's alternatives. Go to the community development director or go the modification route, and I think it's a step forward in issues that have been going on for years, and I think if we can send this forward, then hopefully the rest other issues that came up and have come up over the years can sort of maybe follow suit. But I think if we get one on the ground moving, it's going to be very positive for the effort. I think the items have been well thought out. I don't know if I'd make any changes myself. I do like the idea, though, as Mr. Commissioner Jordan recommended, that there be some type of language here anyway, that some similar issue, when it comes up in the future, could also be handled with the ordinance, so we don't have to open it up again and make some modification. I think that hopefully Mr. Vincent sees that can be handled easily, so that the review and the appeal process would consider other items. Appeal to community development director became centered on an item that's not in this list, that people could use their discretion to include it and say, yes, the intent was there, because it's similar to the other type of items that are listed. That would be probably at this point, given the process that this has already gone through, the only change I would recommend from what staff has put before us for our recommendation to go back to Ordinance Committee. Thank you.
Okay, thank you. If there are no other, Commissioner Schwartz, comments?
Yes, thank you. My recollection from our working group month-over-month meetings is that once we identified and separated minor versus major, we found that most of the alleged violations are in the minor category. And so conceptually, I think that it's very admirable and worthy of developing an expedited, streamlined, efficient process. Having said that, because of the volume involved in minor versus major, any new process, be it this or some refinement or modification of what we see today, is going to address or needs to address the largest volume of the alleged violations. And for that reason, I feel that we have to get it right. So I'm not in a position today to make a recommendation that this in its totality or even with some slight refinements go to council. So I will be abstaining from making a recommendation today. Thank you.
Okay. Well, I'll make a few comments. I think in answer to your specific questions in the staff report, the list of eligible improvements that you propose is a good list. And I agree with Commissioner Peugeot, the comment about exterior alterations in the interior setback. If a window's okay, a door should be handled the same way. I don't see the difference. I would say, in answer to her comment about facade improvements, that I don't see the way you've got it worded here that a facade improvement in side yard interior setback would be precluded because you don't get to that specific detail. So while her point is, I agree with her point, I don't see that the way you've got it worded here would preclude that. I agree with Commissioner Jordan's discussion regarding the idea of appeals, although it really isn't an appeal process, that if a decision, an MZE decision is made at a level of the staff hearing officer and there's still a disagreement, then having another bite at the apple with the staff by elevating it to the community development director, I don't think it doesn't rise to the level of our normal appeal process, but it does give the applicant, the homeowner, an option to have it looked at by another set of eyes. So you might want to consider putting that in there. As far as whether or not to include the provision for conditions of approval, I agree with you. That should be in there because there may be some applicable conditions that are appropriate. And that's it. I would look for a motion to forward this on to the council. Commissioner Jordan.
So I was ready to make a motion, but I'm keeping score here. And I just want to speak a little bit about a door being included with a window in that setback. And over the past year and a half, I have found myself certainly growing to trust Ms. Reardon in her role as staff hearing officer every other Wednesday. And she has an amazing menu of what's taken place in the past, how it applies, what causes a problem, when neighbors get upset. And I have learned from poor experience to, scoff at first and say that's not a really big deal, and then later see and find out that when she thought something was a significant issue, it certainly was a significant issue many, many times more than not. So I'm not willing to make a motion, maybe not willing to participate in including that door in a interior setback for the reasons that she addressed earlier. I think there is a significant, I can agree with her that there is a significant difference on the first floor for a window versus second floor for a window, as she spelled out, and that a first floor door does carry the consequences that she talked about, the comings and goings right up next to the property line, the light in and out, the activity that tends to bring a negative consequence to a neighboring property. So, thank you, Mr.
Well,
Chair.
we don't have to make those kind of detailed determinations because remember, this is going to the City Council Ordinance Committee where we'll have further discussion. It's not going to the Ordinance Committee?
I would like to, Chair Thompson, members of the Planning Commission, I'd like to clarify the process. It did go to the Ordinance Committee already, so the next stop would be the City Council. So
Okay, well-
we would need an answer regarding the appeal process, whether, we're not proposing one to be there. And you would need to, because the resolution would specify, with changes to section, B, B1, 2 to include whether doors, facades, or what. So it's going to be, the resolution is going to be that specific. So it does not need to go back unless we feel it's a significant change and that the Attorney's Office advises us that we should stop back at the Ordinance Committee. But it sounded like the direction that I received from the Ordinance Committee, the first stop would be the Planning Commission and then on to City Council.
Okay, well, I was mistaken in that. I thought our normal process was the other.
I'd be happy to make a motion, but I think I'm going to not be respectful of at least two of you on your remarks I heard, because I obviously want to include the appeal process in my recommendation, but I'm not interested in including the door. So
Okay, hold your motion for a moment. Commissioner Peugeot, you wanted to say something?
Thank you. Yes, save one additional question for staff. I'm also ready to entertain motion. So for staff, getting back to particularly to each of the comments about the door and the facade. On the door, the provisions now exclude the possibility of allowing a first floor door on the interior setback on the side as well as the rear. Is it, as Commissioner Jordan suggested, that you have an identifiable concern for first floor doors on the side and on the rear of a structure?
It would be the same concern because the rear setback's the same. Well, in the single-family zone, it's all interior, but the common term on the street is the property line adjacent or opposite. The front line is the rear. Our zoning ordinance actually does not define a rear lot line in the single-family zone. It's only in the multiple-family zone. So for this, so in the multiple-family zone where there actually is a rear setback identified, I would have the same concerns because it's the same distance from the property line.
So generally speaking, other than the definitional terms of interior setback, it's really the sideline that creates the issue. Is that what you're saying?
The issue is when there's another property adjacent to it.
Adjacent, okay.
So whether it's the rear.
Okay. Well, okay, just to respond to some of the comments here and to a potential motion maker, if there isn't one that jumps up, I could do it. But that being said, I understand that concern. I still would be of a position that I want the facade changes. Is it already covered? I didn't see it covered. Can you tell me that it's already covered in the draft ordinance?
Well, when you brought that comment up, that part is actually an oversight, but I'm trying to think about what kind of facade changes happen on the side that would actually require a modification, and I can't really think of any. We've seen some in the front where like a roof line comes down and it was an element that then they made it into a covering and we called it a facade change. So I can't really think of any facade change that would require a modification, but I'm open to including that in regards to expanding the list of what we haven't thought of.
Yeah. If you're using the term facade in the ordinance and limiting it only to the front. That then results in basically excluding whatever you would consider under that term facade elsewhere. So if you're going to use the term at all, I think it should be for all four sides. So I'm willing to defer to Commissioner Jordan's concerns about the door and based on additional information from staff. At least for now, we can always maybe come back and revisit doors later on. But the facade I would like to see as part of the motion. And I also just want to mention that I would also be supportive of an internal community development department director appeal as long as that still did not require a notice or a hearing.
To perhaps set Commissioner Peugeot your mind at ease, the reason why I think that facades are not disallowed is because it's not mentioned at all. It says if we're talking about facade changes being allowed in the front setback, that doesn't infer that they're not allowed in the interior setback. And so there's nothing that disallows them. What you're saying is if we're going to mention it at all, we should mention it for the interior setback also, but just saying it's allowed in the front setback, to me, doesn't infer that it's disallowed elsewhere. The attorney might want to jump in on my interpretation there.
Yeah, Mr. Chair, I'd have the opposite interpretation. Like we, nothing personal.
I'll remember that.
Like our modifications. You know, you must, the idea of the list of eligible improvements here is similar to the way we interpret our list of eligible modifications. If you have a zoning violation that does not fall into one of the enumerated modifications, you can't get a modification. In this case, if it is not specifically listed, you cannot request a minor zoning exception. So to Commissioner Peugeot's point, I would suggest the solution if we're going. I mean, I don't even know what a facade change really is, but to the extent that maybe someone's done one in a setback and that's become a problem, I would recommend we just add another category for facade changes in the interior setbacks.
You could just add the word under cantilevered architectural features, such as awnings, cornices, canopies, or eaves, or facade changes. How about that?
We'll find a spot for it.
Okay. Commissioner Jordan, go ahead.
So I'll move to recommend staff's presentation as is with the facade change just spoken to. And as part of our recommendation also for staff to propose a what I'm calling and described as an administrative appeal in-house letter responded by another letter without a hearing.
Okay. Do I have a second, Commissioner Puzziero?
Oops, I'll second that.
Okay. We have a motion and a second. Any further discussion? All in favor?
Aye.
Aye. Opposed?
No.
Abstain.
Okay, we have one no, Higgins, one abstention, Schwartz. Staff, any further comments or questions before you wrap that?
No, that was it. Thank you.
Okay, let's take a break until 3 o'clock to allow the next item to be put up on the screen. Okay, we'll reconvene the meeting. Next item is a application. Still not on. Okay, now we're on. Okay, we'll reconvene the meeting. Next item is the application of Tom Meany for project 2321 Edgewater Way. Mr. Busk, you giving the staff report?
Yes, thank you, Chair Thompson. As you mentioned, this is a request for a coastal development permit for a new two-story, 3,505 square foot house with an attached 400 square foot two-car garage. The project site is located in the appealable jurisdiction of the coastal zone. The three main issue areas related to this project and the Coastal Act and Local Coastal Plan are neighborhood compatibility, protection of views to, from, and along the ocean, and directing drainage away from the bluff. So those are the items that I'll be focusing on in this report. Here's a vicinity map of the project, and you can see the project site right here. That's the existing residence. Here's an aerial photo, and again, the existing residence is right here. You can see there's quite a bit of vegetation surrounding the parcel. The existing development on the site includes a 1,945 square foot house with a detached 300 square foot carport and 350 square feet of accessory space. The lot is 14,334 square feet, and it's zoned single family, the E3 zone, with the SD3 overlay, which is the coastal zone overlay. The existing neighborhood is a mix of 1- and 2-story homes. This is the existing site survey. You can see the location of the existing residence and the carport in relation to Edgewater Way. And this is the existing view from the street where you can see the carport. However, the residence is obscured from view. This is a view of the existing 2-story residence. This is the front of the house. And then this is the rear of the house looking north. This is the proposed site plan, and Edgewater Way is along the right-hand side. You've got the driveway to the 2-car garage, and then the house is in the approximate shape of an I or an H, depending on which way you're looking at it. We've got the floor plans here, just in case commissioners want to make reference to them, and also elevations of the building on all 4 sides. This is a colored rendering of the front elevation of the residence, and the architect can get into more detail on this aspect of the project. We also have a landscape plan that gives you information on what's being proposed in terms of landscaping. So specifically related to neighborhood compatibility, as I mentioned, the lot is just over 14,000 square feet. The total net floor area of the new residence would be 3,905 square feet, and that represents a 27% floor to lot area ratio. And that equates to 91% of the maximum allowed FAR within the single-family zone. This project was reviewed by the, sorry, there's a typo there. It was reviewed by the SFDB twice, once in September and once in December of 2014. On September 22nd, 2014, the SFDB requested that the applicant reduce the size and height of the residence and consider removal of the balcony over the garage. On December 1st, 2014, the applicant returned with a slightly revised project that eliminated all of the second floor decks. The SFDB commented that they appreciated the reduction in plate heights and removal of upper level decks, and found the project to be compatible with the surrounding neighborhood. So again, focusing on the 3 coastal policies most applicable to this project: neighborhood compatibility, which I just discussed; views, as noted in your staff report, the project site does not, or the new development would not really affect views to or from the ocean. And with regard to drainage and potential hazards, related to the coastal bluff. The project site is subject to Tier 3 stormwater management requirements, and they have incorporated that into their proposed design. The drainage is not directed towards the bluff, and so staff is comfortable that the project will not have significant impacts related to drainage. Therefore, staff recommends that the Planning Commission approve the coastal development, making the findings outlined in the staff report and subject to the conditions of approval included as Exhibit A to the staff report. And I do also want to mention that we've received some letters and emails about the project, and those have been forwarded to the Planning Commission. There are also a few minor typos and corrections to the conditions of approval that I'd like to go over when the Commission gets to that point in the review, if you're moving towards an approval. And finally, I want to mention that Fred Sweeney, chair of the SFDB, is present and available to answer any questions that you may have. Thank you.
Okay, why don't you go over the corrections you said for the conditions?
Thank you, Chair Thompson. The first correction is on page 3. It's item D1. You'll notice that there are 2 subletter C's, and so the intent is that the first one is C, the next one is D. Also under condition, D1A, the second paragraph, we would just want to be clear that it's to construct approximately 80 linear feet, that's what that LF abbreviation means, of landscaping, and then replace the word in with across, just to be more clear as to the intent. And then on page 4, what's listed as item E, but with the new lettering would be corrected to be item F. At the very end, it says, which requires a maximum height of 3.5 feet, 10 feet back from the edge of the driveway, and 20 feet. And the rest was cut off. It should say, and 20 feet to both sides of the driveway along the subject property. That concludes the changes that we're proposing.
Okay, thank you. Mr. Sweeney, Chairman of the Single Family Design Board, do you have comments that you want to make or give us a rundown of your 2 deliberations?
Mr. Chair, Mr. Thompson, board members, I'm here to answer your questions. Not sure that I need to do a rundown, but if you'd like, I certainly will be happy to do that. It's up to you.
Okay, does anybody have any questions for Mr. Jordan?
Thank you, Mr. Chair. Hi, Fred. So it didn't have a vote on the end of those minutes, but do you anticipate it's just here for CDP, and if this comes back like it is, it's going to pass Single Family Design Board as it is?
I would anticipate that it would. Obviously, there's details yet to be looked at, colors and so forth, yes.
But conceptually, for
conceptually,
size, bulk,
I
and
think
scale and footprint, that type of thing?
Yeah.
Okay, thank you.
Mm-hmm.
Commissioner Schwartz?
Thank you, Mr. Sweeney. Aside from today, you and I began a discussion about floor area ratio and
yes.
Your board's varying ways of evaluating appropriate FARs. And so I'm looking at the 91% on the project today, and I would like your comments on, existing versus proposed 61% versus 91%, and relative to neighborhood compatibility. Do you have thoughts for us about how to
deal with that?
You're the 91%. Mm-hmm.
Yeah, part of the challenge we have with our guideline of 85% is that the circumstances of the site and the neighborhood in the context of how a home sits on the property is a real challenge. When we're dealing with a property that's almost 15,000 square feet, that's a bit different at 91% FAR than it is at 91% on a property that's 8,000 square feet, as we had just this last week with another home over on the Mesa. That's a different kind of contextual setting, and so it's a very big challenge when we're dealing with that FAR. In my view, it's not always tried and true. One of the challenges I think the Single Family Design Board has is that sometimes it proves challenging to be consistent in the eyes of the public who are watching us, because some of our thinking changes. The other challenge that we have on the Mesa is, as in this property here, is that the frontage of the property to the seaside is generally not available to build on. So you have a very large piece of land that can't really be touched for a whole bunch of circumstances, generally having to do with the geology, et cetera. And so that starts to confine the buildable footprint to a section of the property. That's different than a similar sized property, say, on the Riviera, where the total amount of that land could be built on. So that's kind of sometimes the things we have to take into account. On this particular project, we had to take it into the context of what is becoming a changing neighborhood. And I don't know if you have the plan that shows all of the homes along the street. I think it was the first slide you had showed up there. One of the things that's interesting, and I think you were out there this morning, is that within just a few houses, we have 3 or at least 2 other homes that we've also just approved that are now in construction. One just on, I think it's Cooper Road. I think there's a house right there, down a little bit. And then there's one just at the other end of Edgewater that's been rebuilt, completely, torn down, rebuilt. So that's the context we're dealing with, a big moving target, particularly in the Mesa, where we're getting a lot of homes turned over. And so that's a difficult process. I don't know if that answers your question, but that's the dilemma the board faces.
Thank you.
Thank you. And I'd also remind us all that discussing FARs like this 91%, 85% isn't a limit, it's just a trigger point for increased scrutiny. So there's nothing wrong with a project being proposed between 85 and 100%, just means that it's going to be looked at a little more closely. Okay, no more questions. From Mr. Sweeney. You have? Okay, Commissioner Lodge has a question for Mr. Sweeney.
A question for staff.
Oh, I'm
Thank
sorry.
you. Yeah, excuse me.
Going to get to questions.
Oh, you want to do that later? Okay.
We'll do questions after we get our public testimony.
Chair
Okay.
Thompson, the applicant presentation.
Oh, that's right. I wouldn't, getting the cart ahead of the horse here. I don't want to cut the applicant off, but Mr. Meany, are you going to give the applicant presentation?
Yes.
Okay.
Thank you for your time this afternoon, Commissioners. I'm Tom Meany, architect for owner Jeff Behrens, who's here to answer questions as needed, and Aaron Carroll, landscape architect, is also here to answer questions as well. I've got a short PowerPoint presentation. Is it okay if I sit down at the monitor and do that? Thank you.
Just make sure your microphone is on. Green light, press the button. There you go. I want to bring it closer to you.
All right, just to give you a brief overview on the process and our intent and design objectives during the course of the project. So basically, here we are at 2321 Edgewater. As you noted, we're demolishing the existing house and constructing a new 2-story family residence. We're within the height allowance, and right now we're going to be proposing at a total build-out at 3,905 square feet. With our existing build-out is at 2,595, so we're adding a little over 1,300 square feet to the existing house. And in terms of our neighborhood survey, and this is where I look at neighborhood compatibility just from a numeric standpoint, of the 20 closest properties with our new build-out, we're going to be 8th out of 20 in terms of the total proposed FAR. Okay, here once again is a visual you're probably familiar with, showing our property location, surrounded by adjacent properties, an existing 1-story house on the downhill side from us. Here's to show some neighborhood context. As was mentioned, it's definitely a neighborhood in transition. There's some original houses from the 40s and 50s that are 1-story cottages, and then there's a lot of houses that have gone through transitions over the last 10 or 15 years that are typically 2-story. And in some of them, because of just the size of the lot to the width of the lot, you'll have a two-story house 10 feet away from another two-story house. And then because of just the density of the neighborhood, privacy is at a premium down in this neighborhood. And that's one thing about this property that I think makes it unusual, is that it really has a nice built-in private component that we're trying to protect. Here's some other neighboring houses in the area. Most of these are shown as two-story. Inconsistent in terms of architectural quality, but there's some nice things happening, definitely. So in terms of what you find in our neighborhood, of the total houses on Edgewater, 54% currently are two-story. And of the ones on the south side of Edgewater, it's a slightly higher number. So this also helps to depict the fact that it is a neighborhood in transition, because most of these one-story houses are the originals, and the two-story homes are the ones that have been improved. So the existing house is at 2595, built in the early 50s. And as you can see from the pictures in your site visit, it's in poor condition. There is a studio with an attached carport. We have several existing setback violations where the existing house is in both side yard setbacks, the carport's in the front setback, and then there's a funny little sleeping shed in the back that is also in a side yard setback and an illegal structure. The property is very densely shielded with vegetation on three sides. And like I say, that private component is something that's rare on Edgewater, and it's something we definitely want to embrace and protect. And our proposed two-story residence is going to be a little bit shorter in elevation and height than the existing structure. So here's some more pictures of that existing. This is what you see when you come into the wooded section of the property. Here's the backside, and that's the backside of the existing studio. So all of these things will be coming out, but most of the perimeter vegetation is going to be kept intact. So we had a couple SFDB meetings. The first one we submitted, the house was slightly larger. And at that meeting, we had 7 neighbors in support of the project, either in person or in a letter, and 2 neighbors were opposed. And the SFDB comments were looking at reducing the height of the building, square footage, and one of the biggest issues, I think, was just the way we had the second floor balconies positioned on the building and how that balcony placement affected privacy with the adjacent neighbors. And they also wanted to see a complete landscape plan. So what we did is we lowered the plate heights. So we went from we currently have a 9-foot plate downstairs and an 8-foot plate upstairs. We have a completed landscape plan, and we reduced our square footage from 4,050 to 3,905. Additionally, we had 3 second-floor decks that were on side setback lines that we've eliminated, and we have just one central deck in the center part of the house. So here again is that exhibit showing proposed versus new. So here's that existing carport that you guys saw. So the new building starts behind the back end of that existing building. So we're about 30 feet further back from the street than the existing structure. So there's more privacy just because we've moved the building back. We're fixing the side setback violations on both sides, and the new house is in the approximate location of the existing residence. Now, in terms of the privacy, not only do we have the screening component that helps us, but our building placement was something that we took serious consideration in terms of how the placement of the building affects privacy with our adjacent neighbors. If we were back further into the property, our view is better because the sight line widens up. But in terms of privacy with adjacent neighbors, it would become problematic. And for us, privacy is a mutual benefit, so it's something that we were radically trying to embrace and protect. So keeping the building in this location, we really don't have any conditions where we have building-to-building setbacks. Like I say, on some places in Edgewater, especially with this project right here, the neighbors are 10 feet away. So the only place we have an overlap is from this one-story section with the neighbor's garage. Everywhere else, we put the building location to where we're not looking down into anybody else's backyard or into their residence. So this house is accessed from a private drive along here. Private drive continues down into this garage. Conversely, on this side, private drive comes in and accesses this residence. And this existing residence here is a multi-tenant rental. So we originally had a deck here over the office, a deck off the master in this location, and a deck off of the upper bedroom in this location. And so we've eliminated those 3 decks, and now we have just one deck central in this location. So the potential problem of someone being on this deck and looking into adjacent properties, that's totally been mitigated. So here's our new layout with the existing residence. Central room, with a volume ceiling. Like I mentioned, 9-foot ceilings in this area, 9 foot in this area with the bedroom stacked above. Here's that common deck area, and we'll have solar panels facing south in this section of the roof. And here we have a landscape plan, and Aaron is here to give you a brief overview on that concept.
Good afternoon, Chair, Commissioners. First, I'll start by just kind of going over what vegetation is going to be removed on site. There is an existing row of Eugenias here. Some of those will have to be removed for the site distance triangle, but we will be replacing those with a new hedge. There's a pittosporum about here that we'll be removing, and a carob tree. Both of those trees would have to go to Street Tree Advisory Committee for removing those trees. There's 3 myoporums that are diseased in this area that we'd be removing, pretty insignificant trees. There's a nice American linden tree here we'd like to save, but it probably is too close to the garage. There's a mix of palms and birds of paradise back here that would all be removed. However, we would be transplanting this palm off-site, so that would be recycled. This is an older version of the plan here that you're looking at. As far as the proposed site plan, Edgewater doesn't have sidewalks, as you're probably aware. So the pedestrian entry would be through this wood trellis here with a gate. On the newer version of the plan, we've got a vehicular gate here, and the trash has moved from here over to this area. 3.5 foot fence along the front property line, going to a 6-foot fence on the side yards. On the south edge, we're keeping the plantings low for views to the ocean, but to still give some screening to the neighbor to the south. Permeable surfaces include the driveway, which would be permeable concrete or pavers. We originally had it as gravel, but transportation won't accept that material. But we are keeping the gravel pathways on the side yards. A flagstone entry walkway, decking at the front and the rear. Stepping down to a lawn area. For the lawn area, we're proposing a a St. Augustine grass, which is a drought-tolerant species. Probably would only have to irrigate that about once a week. So we're trying to be cognizant of the drought. The bocce ball court is proposed in the rear yard, as is a fire pit around the bocce court. New trees. On the revised plan, we've got a new street tree here. This is a New Zealand Christmas tree here, Japanese maple, 3 citrus trees, veggie bed here. On the rear, just 2 new palm trees here and here. And we're adding a new hedge in front of these existing Eugenias for added screening through there. And along the private driveway side. The planting scheme is mostly, coastal appropriate, drought tolerant, Mediterranean type species. The irrigation system will be all drip, with the exception of the lawn area, and we will have a flow sensor and master valve, which would shut off the irrigation system in the event of a leak. Something you definitely want on a coastal lot like this. I think that concludes the landscaping. Any questions?
Okay, is that the conclusion of your presentation?
More slides.
Okay.
Here are the elevations that was shown earlier. I'll just flip to that. The rendering as seen from the street side. And here's our FAR table. I think it's pretty descriptive. This basically shows very definitively how the neighborhood is transitioning. Here we are right now. We're going to be at number 8 in terms of our total FAR after the project is constructed. Before we're built, we'd be down at number 14. But if you look at the numbers here, they vary from 0.03, which is an 800 square foot house on a 34,000 square foot lot, all the way up to 0.44. So it's a pretty wide range, but generally the houses on the lower end of this table are the original homes, and the ones on the top end of this table are the 2-story homes that have been improved. Coincidentally, the highest FAR neighbor is one of the strongest opponents of the project. Here's some aerial views of the property. There's 2 viewpoints where you can see some of the existing structure that we did a computer model for. Here's our existing driveway, looking down at the new proposed residence. And then there's one other section where you see part of the house from this location, and that's going to be the proposed revision with the new construction. Now here's a table that shows neighbor support for the project. The green are neighbors that have come out either in person or via letter to support the project. The 2 yellow are the ones that have been sending letters and been opposed to the project. And this is the house that's adjacent, has a multi-tenant situation, so that was a neighbor we really couldn't contact. So basically, in a nutshell, we're further from the street than the existing house. The building footprint respects the location of neighbors and privacy. We do not block the views from the street or from neighbors. It's lower in elevation than the existing house, conforms to all setbacks, unlike the existing house, and will be well screened from all neighbors in the street. Comments from SFDB: appreciate the reduction in the plate heights, removal of the upper level decks, sensitivity to surrounding neighbors through screening. Project does not pose any significant visual impacts. Project approved unanimously for Planning Commission review and to come back for final. So in conclusion, it fits well in terms of the FAR rankings compared to the neighborhood. In that way, it's compatible. It corrects 3 setbacks violations. Support from 7 close neighbors. We're further from the street than the existing house, lower in height than the existing house. And also importantly, we don't impact any views from neighbors or from street towards the ocean. Other SFDB comments, we find that compared to some of the surrounding houses directly adjacent, this project poses a minimal, if any, visual impact. Unanimously approved for Planning Commission review, and we can turn for final approval. And that's the extent of my presentation.
Okay, thank you. At this time, I'm going to open up public testimony. I've got 2 speaker slips. Dominic Namnath. And Dominic will be followed by Sally Whitnov.
Still afternoon, good.
Hi.
Good afternoon, Commission. I want to speak in support of Jeff and Christy Behrens. I know you guys are very concerned about neighborhood compatibility. Well, I'm the neighbor. I am right adjacent to the property at 2325. And the work and the effort that they have put in to make sure that it's compatible is beyond anything I would have expected. From my property, it moves their house even further, and the building's further away from my property, which is ideal for me. So selfishly, I like that. And of course, it improves all the values of all the properties in the area. I think the way it looks great, looks fantastic. And I just urge you to just approve the project as is.
Okay, thank you very much. Sally Whitnov.
Good afternoon, Commissioners. I'm the house directly across the street, so aside from Dominic, I'm probably the one that's most impacted by it. From my upstairs bedroom, I look right at the current home that's there now. Christy and Jeff have been amazing about how they've contacted us, checked with us, what views are important to us, so that their house doesn't look into our upstairs bedroom. They've taken all that into consideration. I think the project looks great. I would just like to support it and encourage you to go ahead with it. They've been very, very considerate of the neighborhood in making this proposition. So thank you.
Thank you very much. That's the last speaker we have, so I'll close public testimony, and it's back to the Planning Commission for questions. Any questions to staff, Mr. Sweeney from the Single Family Design Board, or the applicant? Commissioner Lodge.
Thank you, Mr. Chair. The staff report says that it's 91% of the required maximum floor to lot area ratio, the FAR. Then the 20 closest lots chart says the FAR is 0.27. What am I missing here?
Chair Thompson and Commissioner Lodge, there are two numbers that we use. One is the actual FAR, which would be the true closer ratio of the house size to the lot size. But then within the single family zone, we do have formulas for how to calculate what the FAR should be. So it gives a certain size to lots of a certain size, and then you get an additional percentage based on your lot size above that. So it's not a strict calculation. And so the 85% is seen as a good guideline. 100% is the maximum. This is a lot that's under 15,000 square feet, so it is a required consideration. But that's why you're seeing the 0.27 versus the 90% or 91%.
Thank you.
That it? Commissioner Higgins?
Thank you, Mr. Chair. To Mr. Sweeney's point that he was making earlier, was your point that the site constraints contribute to the size, or I guess the bulk of the project, in that they've elected to squeeze the home in a tighter fashion than they ordinarily might, maybe because of site constraints or privacy, and not that your point was that the FAR could change? Could you maybe clarify that for me?
Sure. Well, one of the things that we also deal with is the size, scale, and bulk. And typically you'll find folks try to say all three of those at the same time, but they really do represent different issues. So one of the things we looked at is the bulk of the building, the massing of the building, and how it related to the adjacent neighbors. And that's why we suggested after the first visit to the Single Family Design Board that they consider moving the building just slightly from the first time they shared it with us, so that we moved it out of the way, I think as Mr. Meany just demonstrated, out of the way of potential privacy issues between the properties. And that also had to do with the placement of the decks. So that was the bulk issue. The sizing and scale issue, the scale issue was getting them to reduce the plate heights, to push the roof height down, to push the floor heights down so that the building wasn't so tall. So that was kind of those two things we thought were more critical than maybe necessarily the size, which is the relationship to the FAR issue.
That it? Okay. Commissioner Jordan, questions?
Thank you, Mr. Chair. Allison, I just have a couple for you. I was looking really quick. I couldn't find, and I'm embarrassed, but how does a total knockdown not get out of Tier 2 and into Tier 3 for stormwater?
Chair Thompson and Commissioner Jordan, this is a Tier 3 project.
Okay. I swear I saw
There
somewhere.
was, I believe in the applicant's letter, it said Tier 2.
2, right?
But this is
Okay.
a Tier 3.
Very good. And then on the clause, the little template clause we have in there for construction staging regarding parking, the working interpretation of that without an approval from further approval from the city is that trucks would not be parked on the street. Is that correct?
That is correct.
Is that it's so? You know, I'm 530 feet away from this property, so 500 is the key word there. And you've heard a little bit about the construction that's going on down there, and I drive that every day. Everybody I know walks that every day too, and it's not pleasant right now. But is that just a complaint-driven result or response? And do we hand those approvals out administratively regularly, or do we not hand those out?
Chair Thompson and Commissioner Jordan, we do respond only on a complaint basis for trucks parked in the road, and that would depend on whether or not those other projects also had conditions of approval. I don't know specifically if they did, but for this...
They're all about the same, so I think they have the same template. But does the city routinely approve approvals like that or not?
The Public Works Department does approve those on an administrative level. Whether they approve them routinely, I don't know. I don't know that they get a lot of requests in neighborhoods like this because often people will just use the street without asking for permission.
Thank you. Thank you, Mr. Chair.
Okay. Commissioner Schwartz, questions?
Yes, thank you. Regarding landscaping, vegetation, I'm looking at the DART submittal letter dated June 29th. Is this still current? Is the project before us today still current relative to the DART letter regarding number 8, tree and vegetation removal, and from what the landscape architect discussed with us today? It says here all large trees and shrubs will remain. It says all these, and it's not specified what these are. So if I could ask you to comment first on that sentence.
Not everything is to remain, no.
I didn't think so from our site visit. And what do we have some kind of delineation or a slide, Mr. Meany, or does anybody have from? And I'm interested in this because I think to some of those neighbors who are either concerns or just sensitive to whether we call it the FAR or the size of the proposed home, the screening is critical to a feeling of the semi-rural nature there, the privacy, and so forth. So if you could go over that with me, I appreciate it.
Absolutely. I guess you're referring to the front yard screening. Is there an area you're in particular you're interested in?
The front and then the side. Yeah.
Well, the side yard screening is proposed to remain, and we're even adding additional hedges there. A portion of this front yard screening may or may not have to come out due to site distance issues.
Due to site distance?
Yeah.
You mean line of sight?
Yeah,
for
line of
safety
sight,
purposes?
site triangle.
And is that our transportation groups?
Correct.
Feedback to you for safety?
Ingress,
egress.
The carob tree here, we had to remain on the first plan, and it could feasibly remain, but the owner would like to remove it. It's not the greatest tree in the world, and we'll be replacing it with another tree in a similar location there.
For these trees that you'd like to remain, has an arborist or perhaps yourself done a study to determine the health of all of these trees? Just should you be allowed, should transportation safety allow you to keep them? So do we know the survivability? Because this is an issue around town where for the drought, we now have a lot of trees threatened.
The myoporums, which are just a few here and there, have thrips. Mm-hmm. So I would suggest removing those for that reason. The Eugenias would survive for sure. That's these really tall guys that you see here and along the west and east property line. And the palms in the back are pretty minor as far as.
Well, the grouping of palms, we know that's being donated to UCSB, that it's at the far back part of the property. Mr. Barron's mentioned that to us. On the side of the property, and I don't know if this is in SFDB's hands, but with the screening so integral to the goodwill of the neighbors and protecting privacy, et cetera, is there any aspect to the landscaping plan such that if on the side, the property lines to either side, those what are now very tall trees, initially intended to be hedges, as it's mentioned here in the DART letter, if any of those fail, diseased, they die, they need to be removed. Do we have a removal plan that's, I don't know, Ms. DeBusk, if you have any information. Sometimes we require that on projects where it's the landscaping is so important to the whole of the project or a particular aspect that we require that replacement be incorporated into conditions of approval. Is there any thought, or I don't know, Mr. Sweeney, if the SFDB contemplated that as well?
Commissioner Thompson and Schwartz, that is certainly a condition that the Planning Commission or the SFDB could apply if they felt that the screening was critical.
Mr. Sweeney, was there any contemplation of that yet by your board?
Yes, we did have that discussion because I believe it was the neighbor to the west did attend one of those hearings and was quite concerned about how that screening was going to work. So I think staff is correct. Either our board or your action would set that into motion. probably has a little more weight coming from the Planning Commission than it does from Single Family Design Board. So if that's part of your decision-making process today, that's fine, and then we'll follow through with the specifics at SFDB.
Okay, and one more landscaping question then. Under, again, in the DART letter, now this is under the section titled Landscape. In terms of choosing St. Augustine, you mentioned, sir, that it would require weekly watering. We have a number of other turf products, species, on our approved list in the city that require far less watering. So I'm wondering if you've contemplated those, and if not, if you would, especially in that area of our city, towards the bluff top.
The St. Augustine, in my mind, is just as drought tolerant as maybe a San Diego bentgrass, which you see at Lobero. That's a native grass. We could use that, but I think the St. Augustine is just as drought tolerant, it's particularly on the coast here where you're going to see a lot of foggy summers. But we're open to that discussion of different turf species. I think we'd like to keep it a real turf if possible, and not
Yes,
go
I
artificial.
understand what you mean. A natural grass.
There's some native seed sod blends. S&S seeds grow. We could look into those. If a native grass is desired, but.
In the past couple of years, the Planning Commission in the general bluff-top area of the Mesa has approved other new landscaping plans with more drought-tolerant and very attractive and approved natural turf. So I'm probably going to incorporate that into my recommendations to my colleagues as part of the conditions. Thank you. Those are my questions for now.
Okay, if there are no other questions, Planning Commission comments, and then looking for a motion to forward this. Commissioner Peugeot.
Thank you. First of all, I want to say that I think that the applicant and his team have done a fine job of their proposal. The first thing that I will address is the size and the FAR. I don't have an issue with the size of the house per se. It is a large lot, and looking through the list of closest 20 lots, I would just like to mention that of the lots that are larger than this one, there looks like there's about, 4 or 5 of them that are larger than this one in square footage, not the house, but the square footage of the lot. Just would like to note that even though those houses are smaller, and the applicant has mentioned that probably are some of the older ones, those homes actually have some potential still, if they're the same zoning as this one, to perhaps split into 2. So we can't foresee what the intention of maybe some of those property owners are in keeping their houses small, but because this one is larger, I think it does have sufficient property surrounding it, and it isn't large enough to be split, that we could probably count on the grounds and the proportion of and the size and bulk to be in proportion to the size of the property around it. So I'm fine with the size of that. I'm also my understanding of the Mesa, and I did live up there in that neighborhood for about 6 years once upon a time. Some of those properties along Edgewater on the ocean side of the street, there are a few and there are others that traditionally have been somewhat larger than ones in the other portions of the neighborhood. So I'm fine with that. I agree with Commissioner Schwartz that the character of the neighborhood, particularly for those properties along that portion of Edgewater on the ocean side, that character is defined really in large part by the abundance of the landscaping and the screening. So I do think and would support any conditions that supplement the importance of maintaining a dense screening from views along that property, not only for the adjacent property owners, but the public views through the property. And there are, to that end, and I don't know where the language would go, I have some wording I could propose, but I would see a couple of places where we would need to incorporate that. One is I also agree with Commissioner Schwartz that we should have a more definitive list of those trees that are actually intended for removal. And I don't see it in front of us. Partly that could be because we didn't actually, I don't think, get a landscaping plan in our package. But I think that it would be a good idea to actually list out those trees that are being specifically removed in a way that that list wouldn't be expanded after the final approval. May I finish? And then more importantly, even perhaps, is on page 2 of the conditions. It's the only place I can see to put it most likely, and under the landscaping compliance, I think I would like to see that language beefed up to include language that requires dense screening of the property. And with those two things, I think that it would be much more in line with the finding for compatibility and public views that we need to make. And I think you're there already in your design. I think what we want to do is confirm that through our conditions. And I appreciate, some of the screening that you've already shown us on your landscaping plan today, but that's a little different than including it in the conditions of approval. There is one more item that I think should be beefed up in the conditions from my view. And since it is a complete tear down of a property, there's going to be a lot of construction debris because it's a substantially sized house already right now. So I would like to see something in the conditions that protects from, say, stockpiling of those kind of debris for maybe more than a couple of days or whatnot. I'm not sure if we really have nailed that in the conditions right now because we are expecting potentially a very rainy season. And I don't think that stockpile of debris and construction dirt removed should sit on the property for a lengthy period of time without removal. Those would be my comments.
Okay. I understand the applicant has a response regarding the tree removal plan. No, if you want to talk, I'll allow you to come up to the speaker podium and talk, but if you're not going to address Commissioner Peugeot's question, it's the Planning Commission time right now.
Oh, no, I was going to address her question.
Okay.
So just to talk about the screening a little bit more, the concern, it's hard for me because I want to be able to point. I don't have a pointer. Thanks. Okay, sorry about that. Okay, so this neighbor here, this is Carol and her husband. This is her garage and this is her home. They're the neighbors that initially had the problem with the building. So what we came to agreement was this hedge that runs down the whole side of the house here, that where the house is from here all the way back, the intention was to keep that at the height of the roof line. And then here going from the garage, where you can see their garage lines right here, from here forward, we were gonna just trim that down to their roof line, so we would be able to pick up a little bit of the view. But it wouldn't impact any of the privacy of looking back into their yard here. And the same thing here. The intent here was to keep all this at the height of the roof line here. And the intent is also to try to keep all this screening as much as possible. And where we have to take out trees, then replace that with other vegetation that that will keep that screened, because that's to our advantage to have as much privacy in this whole area as possible. So we'll definitely address that. And as far as a different turf, we don't have any problem with that. So happy to do that. And as far as removing of dirt and everything, I plan to do this as owner-builder, and I want to run it as clean as possible. So we will do that. And one of the other things that came up with some of the neighbors was asking us if we could make sure that we didn't start before 8 o'clock, because I have 2 neighbors actually that have medical issues, and we're in complete agreement to do that as well. So
let me just say,
thank you.
Yeah, thank you. And I do appreciate that. And what you are speaking to, I think, is actually showing itself well in the plans as much as I can determine from here. And so I appreciate that. And I think what we're asking, at least what I'm asking, is that some of that be codified in the condition language.
And the landscape plan is one of the items that's reviewed by Mr. Sweeney's board, so they will be looking at that in more detail. Commissioner Lodge.
Thank you, Mr. Chair. I have a real problem with this project, which hasn't been mentioned at all. And I know this isn't the intent of the current owner, but the west upstairs section is a perfect future vacation rental, or even, not a vacation rental, even a home shared rental, or a separate apartment. Overall, for me, the building still seems bulky and large. And the office space looks as if it's about 300 square feet, and it just seems inappropriate. While the house may be number 9 in the FAR ranking, it is by almost 500 square feet larger than the next largest house. And it's almost 1,500 square feet bigger than the average house there. So I really still have a problem with that, and with the issue of future owners. The Barons won't always be the owners of this house. It's not likely that they will be. At the site visit, I brought up this issue of future use as a separate unit, and staff said that conditions could be put on it that would at least put people on notice, future owners.
Chair Thompson and Commissioner Lodge, we do have a standard condition that requires a zoning compliance declaration, which gets recorded and lets everyone know this is one residence and shall not be used as more than one residence. So it's some added, comfort that it will be used the way it's intended.
Okay. Thank you.
Thank you. Commissioner Jordan.
Thank you, Mr. Chair. So I think much of what I've heard is for concerns is in the sweet spot of the single-family design board. And if people really want to craft a condition, that's okay, I guess. But I think I would prefer that we leave the flexibility of what that's going to read back down to the single-family design board. I am pretty much a neighbor. It's outside my little circle of influence, so I'm sitting up here today, but I'm on that road daily. And I agree it's a big house. I also agree it's a big lot. I don't have any problem with what you're presenting. I think you've done admirably in setting your building envelope where it will have little consequence on your neighbors. I know you had 2 of them in front of you here today out of the 3 that would be most affected, and that's a good sign to me. It's always interesting to me to see these FAR lists and see people get worked up about those and never really recognize exactly what Mr. Sweeney said, and that's it. When you look at a lot that's a smaller lot with a smaller FAR, sometimes that whole presentation is much worse than looking at a large lot with a large FAR, just because of the dynamics of percentages on more space. So I don't have a problem with the way it's presented. I'll follow along, I think, with anybody's attempts to put any conditions on those, as long as it doesn't drastically change what we're seeing here. I just have a couple comments for Mr. Sweeney to take back home with him, and one just concerns anything you guys can do to help with the street side parking. It's been miserable lately on Edgewater, as the architect has talked about, and it actually gets worse in the winter with surf visitors rather than summer visitors. So, and one of the benefits of that neighborhood is that everybody gets to walk in the street, and they like that little rural feeling to it. One of the consequences of that is everybody's walking in the street, and you can actually get a little bit back down on the project we just have seen completed on the corner of Edgewater, and that's the skinniest part of the street, where we had a nice long conversation a year or two ago about sidewalks or no sidewalks, and if you park 2 cars there, you cannot put another car through the street with people in the street. I can tell you this from experience. So that's one point. And the other point is, I heard reference, although I didn't see it on your picture, to a vehicular gate and what that would look like. In this neighborhood, I am increasingly concerned with, I guess, the estateization of parcels, to where they are hidden behind a gate and a fence or a hedge and have no street presence anymore. And I think that is drastically attempting to change the character of probably any neighborhood, but this neighborhood too. And so my 2 cents back down to the Single Family Design Board would be to make sure that this development continues to offer a presence to the street as a house rather than an estate behind a tall gate or fence and a set of hedges. Thank you, Mr. Chair.
Thank you. Commissioner Higgins?
Yeah, I'm prepared to support the project. I think you've done what you can with the constraints on the property, and you've listened to your neighbors. And so the effect of that is to squeeze the buildable square footage of the home into one area, so it does exacerbate the bulk. But relative to the FAR guidelines and standards we have, you're in good shape. I sort of think the floor plan is pretty interesting, to allow for some privacy in the other parts of the house, multi-generational living. Something that we don't talk about very much, but it's something that we ought to be prepared for. And so I commend you in that fashion. I think that's a interesting way to design the project. So I don't think there's much to make about views. You're not on the bluff top. There's no views there currently from the street, so I don't have a problem with how much house appears in your elevation to be in the view corridor, because I don't think it really reflects what's on the street now. So I don't see any need to add any conditions of approval. And I can I'll just say that I support the project, and I appreciate Mr. Sweeney's reminder about FARs and how those can change based on the total square footage of the lot, obviously.
Thank you. Commissioner Schwartz.
Thank you. First, to address Commissioner Lodge's concern, let me clarify, if I could. Is there any outside access, external access to this other area that may be viewed as a potential rental portion of the
There's no
structure?
exterior door in the side setback. There's no exterior stair. So the only way up to the upstairs is through the front door and then up
Through the
the
front door,
interior
absolutely
stairs.
no
Yeah.
side doors, nothing that we might be missing there.
No.
Okay. So a few thoughts. First of all, Mr. Higgins said the design is very interesting, and whether it's the Barons living there or it's another family, I think the reality for our society is, and actually I think it's a hopeful one, is that we are bringing our parents whoever the next generation is that has the parents, bringing them into the homes, welcoming them in for intergenerational living. And I think we need to adjust to that as land use planners and as community decision makers to trying to find a way to embrace that and to support that. Now, in terms of the size of the home, Mr. Sweeney continues to educate me about this notion of we need to look at this three-dimensionally. It's not a two-dimensional or certainly not one-dimensional set of considerations. So I think for the size of this lot and the way you're citing this square footage, which is significantly larger than what you have today on the property, I think it's acceptable. I can support it. The landscaping is key, and we've talked about that, but I just want to drive that home. And so whoever the maker of the motion is, and I think Ms. Peugeot outlined everything in the conditions of approval probably that I would support, I want to make sure that that's a commitment, recognizing that for all the reasons we've already discussed, including this very important semi-rural feeling that exists in this micro neighborhood within the Mesa neighborhood. It's so unique, and I think that every single project that comes to us, every property that turns over, must be scrutinized very carefully for that reason. Coastal views, although you're not right on the bluff top, many probably would consider your property to be bluff top for all other intents and purposes. So I'm fine with that, with again, some conditions of approval and specific notes to the landscaping. Let me see if there are just a couple of other comments here. I think the design is actually an enhancement to the neighborhood. On the one hand, you know, it's easy to feel nostalgic or to be nostalgic about some of these original small one-story 1940s and 50s homes there. Quite frankly, some of them are not attractive aesthetically at all, even though they're smaller in scale and it's more of a human scale and it reflects back to another time on the Mesa. You know, we also used to have onshore oil oil pumps and, you know, men's strawberry fields on the Mesa. So a lot has changed on the Mesa and it continues to change. And I think we need to strike a balance in allowing for change without it not overtaking some of these very special qualities of the Mesa, which I'm guessing is why you and your wife purchased the property when you did. So with that, I would be interested and supportive of certain changes to the conditions of approval. Because I'm losing my voice from having a cold recently, hopefully one of my colleagues can put that forward. But for now, in general, I'm supportive of the project with some slight conditions of approval changes. Thank you.
Thank you. Commissioner Campanella.
Thank you. I, too, appreciate the process that developing this site has gone through in the House, both by the Single Family Design Board, the architect, and the owner. Also accommodating the neighbors according to their concerns. I think as it's set up relative to evaluation, one item, too, is a significant setback that the house now has in the structures from the street, which is more than you'd see in other areas of the neighborhood, significant. Size, bulk, scale evaluations were done very well. Also, sometimes you look at the footprint, you know, relative to the unit, relative to the land. And this, I think, is a modest footprint, functional because two wings are really upstairs rather than being spread out on the lot. Same FAR, but again, the fact that the bedroom areas are upstairs, I think, are good. It's not a three-car garage, it's a two-car garage. Nice elevation change between the first and second story. A lot of those features, I think, are incorporated. And also, it's a multi-generational house with the interior space, common area downstairs, pretty functional. Not overly done, but functional for the uses. Landscaping, I agree with. I think we, perhaps in a motion, should beef that up a little bit and have Single-Family Design Board go at it, but with our hope that the mature landscaping would stay in place across those side yards. Let's see, I think that's about it. Coastal concerns, I think it satisfied everything relative to a lack of impact. And as was corrected, stormwater 3 preservation is going to be in place. We satisfied ourselves on the field trip that There wouldn't be any drainage going on to the lots to the south, the coastal lot, and also that water is being retained on the site and being sent out to the street. That amount that's not being percolated into the ground itself. So I'm in favor of supporting the project, making the findings that we were requested to make by staff. Thank you.
Thank you. Commissioner Jordan, have additional comments?
Yeah, thank you, Mr. Chair. Well, I just wanted to respond to the question and what I heard Mr. Meany say. There is the question was exterior entrances causing a concern for potential second units, and your answer was there's no door in an interior setback, which wasn't really an answer. There is a door for a mudroom on that west side there that is off the set of stairs that lead upstairs to an office. And there's no bathroom there, but it's over what I assume would be plumbing in a mudroom, and I think that's the concern. And so I want to make sure that concern's brought up verbally in front of Mr. Sweeney, so he's much more an architect than I am, just dabbling in it. So, but that when somebody looks at the potential there, I think that's what they're talking about. It's not a door in a setback. It's just a door with access that can be roped off from the rest of the house. Okay. Thank you, Mr. Chair.
Thank you. Okay, if there are no further comments, we are requested to give a coastal development permit, and I'd be looking forward to a motion to that effect. Commissioner Peugeot.
Thank you. I would move to approve the project, making the findings in Section 8 of the staff report, particularly the finding about consistency with the California Coastal Act and consistency with the city's local coastal plan and other applicable policies. And I imagine, was this exempt from environmental review? And the exemption from environmental review. And I would add a couple of condition changes. The first would be on page 1 of the draft conditions under section 1B1. And in that section, in the third line from the bottom, I would incorporate a phrase. So that line more or less says, it has the wording that says 2-story single-family residence, a 400 square foot attached 2-car garage. And this is the section I would change, and it says, and the improvements shown on the plans, the addition would including specific trees designated for removal, and if removal is necessary due to disease, replaced with comparable trees. That would be added to that section. Maybe the language could be a little more smoothly crafted by staff, but that's the idea there. And then the second change I would propose is on page 2 of the draft conditions, and that is condition B4 under landscape compliance. I would add a new second sentence, and that second sentence would read, to the extent feasible, provide landscaping at a height and density that heavily screens the structures from public and neighboring views. And then the last item I would like to include somewhere, and I don't know if staff can help me with this one, the best place I could find would be page 5 of the conditions under construction, storage, and staging. But I'd like to see something in there that would say that any debris stockpiling shall be removed within, maybe it should be 72 hours, or I don't know if you have a standard for that you would like to add in there. But since it is a complete tear down of a significant structure, I think it would be warranted to say something about that demolition portion of the project in there.
Are you referring to page 5, number E2?
Yes, that is
Okay.
correct. That would be my motion.
Okay. We have a motion with some modifications to the recommended conditions of approval. Do we have a second?
Second.
Have a motion and a second. Any further discussion? Commissioner Lodge?
Thank you, Mr. Chair. Would you add to the conditions the, what?
Zoning
Mr.
compliance
Debus
declaration.
Suggested, pardon me?
The zoning compliance declaration.
The zoning compliance declaration.
I would be fine with that. Have we seen that in our conditions before? I mean, I think I understand what it does. Just puts the owner on notice and any future owner that there's a single-family dwelling, and is that about the sum of it? Because I don't think I've actually seen one before, but I would be fine with that.
Okay. Is the seconder also in agreement?
Second is in agreement.
Commissioner
Thank you.
Higgins, discussion?
Just a point of order, I guess, for Mr. Chair to the applicant. Is that, are these okay? And the 72-hour debris removal is okay with you? Okay.
Any other discussion? Okay. All in favor?
Aye.
Aye.
Are there any opposed? None opposed. Okay. Project is approved, and it's appealable to City Council in 10 calendar days. Good luck. Okay, this brings us to our administrative agenda, Staff Hearing Officer Liaison Report.
Thank you, Mr. Chair. Just 3 quick items last week. None of them any more substantial than just modifications and improvements in a current non-conforming setback.
Okay. Other committee reports? Commissioner Higgins?
Parks and Rec Commission met last week. It was in the paper. They deadlocked on improvements to Cabrillo Ball Field, primarily centered around the basketball court concept, and so that's now punted, to, as I understand, to HLC to review both design concepts, and then it would come back to Parks and Rec.
Okay. Commissioner Lodge?
Thank you, Mr. Chair. At the October 21st meeting of the Historic Landmarks Commission, they had before them the citywide wayfinding signage program, which you may have all heard about, which received favorable comments from them. These very attractive boards with a distinctive shape. And they're going to have blue backgrounds in the harbor area, brown backgrounds in EPV, and green backgrounds elsewhere. The other thing that they acted on that I was surprised to see it had come back to them, but it was a request again to move the Crossroads brick sculpture in the middle of the 600 block of State Street back down to the middle of the grass area by the train station, which HLC had turned down at a previous meeting. At this meeting, they once again said they didn't like it in that situate location, but they suggested putting it at the end of Chapala, where it dead ends at the railroad track. And everybody liked that idea. So that's where it is going to go. Its approval has been given to moving it, and where it was, the brick will be filled in to match what's existing. Thank you.
Okay, thank you. Commissioner Campanella.
Thank you. At ABR, this past week, the average unit density project 604 Coda Street received final design approval. It still needs, I believe, a stormwater management plan approved, but then it would be ready to go to building department. Coming up Monday at the next meeting is 1818 Castillo Street that we're aware of, which was going to come to us at one time, but is going back to ABR. The project has been redesigned. I got to look at it downstairs at the Garden Street office, and I'll report further after I get the comments from the meeting. I'll report to you at our next meeting on how ABR evaluated the project. Thank you.
Okay, thank you very much. And Tonight is First Thursday for those that want to avail themselves for a downtown night out. And with that, we're adjourned until next week.
Come home. Come home. It seems to me I've heard that song before.